अपने भाषा में न्याय, right? So that I say that unless the law schools, you propose this to the law schools, and they train the lawyers, because we are trained in English. The medium is English, so it's very difficult for us to now go back. So if you want to start some movement on that, we have to see to it that the legal education imparted is also in local language.
Sir, all law colleges in our region, they teach in both the languages, English
Oh,
as well as vernacular Gujarati, and the question papers are also in both the language, and students have the freedom to answer questions in English, Gujarati or Hindi.
that's
So
great. That's a
एक
good.
सेंटेंस हम क्लास में गुजराती में बोलते हैं, दूसरा we speak in English,
That's I think
and all of us are used to it. Even Shanaz madam, Kitna
it's
madam.
very welcome
Yes,
change.
thank you very much.
It's not because of the practice. It is because of for whom we are doing it. The law is aimed at common man, so it should be understood by the common man. And others maximum of the ignorance of law is no excuse. He is otherwise ignorant. And he can't take excuse also. So he is already taken the beating. So that's the thing. So
Right.
that's
So
why.
we,
So for him, and also we are advocating. In fact, 2018, now Supreme Court, all the orders and judgments are in 9 languages. So
fine, sir. That is also. Rajesh Bhai, welcome. Rajesh sir has joined us, Chairman of Sarvajanik Education Society. Welcome, sir.
Good morning, everyone.
Good morning.
Sir,
Good morning.
Good morning, sir. Namaskar.
Good morning. Good morning.
Very good morning.
all the,
Jai Shri Krishna.
Jai Shri Krishna, Jai Shri Krishna, Mendra bhai.
can we start now? All the dignitaries have joined for the inaugural. I think we can start. Anisha, madam, please begin the conference.
Yes, ma'am. Before we commence the occasion, I request all the participants to please switch off their mic and video. A very good morning, ladies, gentlemen, and my dear colleagues. It is a special honor and privilege for me to welcome you all on behalf of VT Choksey Sarvajanik Law College to the second virtual 2-day national conference on expanding horizons of consumer rights. I bid a very warm welcome to all the renowned speakers and delegates who took their valuable time and joined us today to be a part of this conference. We are honored to have you all with us. I would also like to offer my regards to all the people who made this conference a reality. More than 700 students and 32 paper presenters participating in this conference at national level. This is a huge success in itself. The theme of the conference is expanding horizons of consumer rights, which enlighten and provide us with approaches to deal with the problems of tomorrow. With all this, I request the conference chair, Dr. Irmala Dayal Madam, in charge principal of VT Choksey Sarvajanik Law College, for opening remarks. Over to you, ma'am.
Thank you, Anisha, madam. Good morning to one and all. On behalf of Consumer Club of VT Choksey Sarvajanik Law College, I welcome you all in our second virtual 2-day national conference. Formal welcome address will be delivered by our own chairman of Sarvajanik Education Society, Shri Rajesh Desai, sir. Welcome, Rajesh, sir. On the onset, I would very briefly share some details about this conference. Approximately 710 participants from all over India have registered for this 2-day virtual conference, and around 32 papers shall be presented in these 2 days of meaningful deliberations. Papers which will be presented in this virtual conference will be published in an edited book with ISBN number. Our publishers are also like publishing books at national level, so they are national level publishers. I would like to share one more recent achievement of our formulator of the conference, Advocate Shri Shreyas Desai sir. એમના achievements તો બહુ હોય છે, પણ એક recent છે એટલે I'm sharing with you today. He has been recently awarded and appreciated by our very own Honorable Chief Minister of State of Gujarat, Shri Bhupendra Bhai Patel sir, for his special contribution in the field of consumer protection and banking laws. With this news, I would like to share my screen with all of you. I would just share the glimpse of the book jacket and Shreyas sir receiving certificate of appreciation from our Honorable Chief Minister, and then Rajesh sir will take over. Give me 1 minute's time only. This is the book jacket of our proposed edited book with ISBN number. Parikh sir is also going to send in some write-up for this conference. Even I am writing editorial section. So it will take some time, but we'll try to release it as soon as possible. This is the table of contents. These are the papers which we have received, and these authors will be presenting these papers virtually in these 2 days of deliberations. We have even mentioned the name of the authors and the titles of their research papers. 32 in all. And now I share the photograph of Shreyas sir receiving certificate of appreciation from Honorable Chief Minister of State of Gujarat, Shri Bhupendra Bhai Patel. With this, I hand over to Anisha Madam to invite Rajesh sir. Thank you, all of you. I'll just a minute, ma'am, stop sharing my screen. Yes, Anisha Madam, I've stopped my presentation.
Thank you, ma'am. I now request the presiding officer of today's inaugural function, Shri Rajesh Desai sir, who is chairman of Sarvajanik Education Society, as well as practicing CA and proprietor of MR Desai and Company over Fort Gill. He is also a visiting faculty for taxation at C.D. Burfiwala College, Surat. He has published various articles of taxation. Thank you so much for coming and bestowing us with your own presence. Thank you so much for doing so much for us. Please welcome Shri Rajesh Desai sir. Over to you, sir.
Mic, please. Sir, you are muted.
Sorry. First of all, once again, good morning to everyone. And I congratulate Advocate Shreyas Desai for his recent achievement. And Shreyas, we are proud of you to have you in our management and part of our college's local chairman.
Thank
So
you, sir.
congratulations.
Thank you.
It gives me immense pleasure in welcoming today's chief guest, Justice Honorable Sri Mahendra Bhai Parekh, Justice Honorable Sri Vishnu Kumar Patel, our keynote speaker. Both of them are retired judge of Gujarat High Court and have earned a high reputation through n number of their landmark judgments during their tenure, and also by their valuable contribution towards Gujarat State Consumer Dispute Redressal Commission in the capacity of president. Sir, we value your presence on this platform and extend my sincere thanks on behalf of our organization for sparing your valuable time and honor your immense contribution in the field of law and justice. I'm equally glad to welcome today's guest of honor, Sri Advocate Senior Supreme Court, Sri Sukumar Patjoshi, who is an eminent advocate by his great contribution to the profession, and because of that, he is recognized as senior counsel at Supreme Court, which is a great achievement and recognition too. Sir, I extend my thanks to you also for your presence. I also welcome our Provost, Professor Percy, and two colleagues senior advocate Sri Kamlesh Bhai Patel and Sri Shreyas Desai, other dignitaries, students, and all participants on this platform. The core subject today, which is expanding horizon of consumer rights. This subject is such an important subject mainly because of two reasons. One is it affects and concern to every citizen of our nation. And number two, it is protection of right to realize value for money. Of course, it's sorry part that in absence of such an important law, every citizen of India has paid great price for so many years after independence. But still, der se aaye, durast aaye. In 2005, this act has come into force. Now, after introduction of this law, we the citizen can't afford to suffer anymore for lack of awareness about our right. So the importance of such seminar is much more. This Sarvajanik Education Society has been renowned prime institute and the oldest institute in the field of education since 1912, whose slogan itself conveys the prime object, which is Tamso Ma Jyotirgamaya, Andhakar thi Prakash Taraf. And we can proudly claim that we have been able in achieving and maintaining our goal. We are working with 14 colleges, 4 research centers, and nearly 14 schools, where 32 to 33,000 students are taking their education. And VT Choksi Law College is one of them. It reminds me that this college has produced many eminent judges and lawyers. To name some of them, Supreme Court Judge Sri D.A. Desai, Supreme Court Judge Sri Aziz Ahmadi, Gujarat Court Judge Sri Behram Techna. So we are proud of this institute, and I congratulate the principal, local committee chairmen, other professors, and who are contributing for organizing such seminar. We all know that this century is a knowledge-based century, and we have also realized that now and onwards we cannot afford to be just restricted of degrees. We have to go much more out of there, and we need to expand and enrich soft skill, and which can be achieved through this sort of seminars, symposium, interactions. And I'm glad that this college is very active in delivering their obligations in this direction. So I congratulate Srimati Dayal, Sri Shreyas Desai for their active participation. At the end, I would submit that ideas flourish only when vibrant mind thinks them and amicable hearts put them in action. So such seminars, symposium always provide a great platform in that direction of interaction, discussion, expression, and enrichment of one's knowledge. I am sure that with this seminar, whosoever participate at this platform will be enriched in their knowledge, and I wish this seminar a grand success. Once again, thank you very much, everyone who have participated and for their valuable presence. Thank you very much.
Thank you so much for gracing this occasion, sir. Thank you.
Thank you, sir, for taking out time despite your busy schedule. I request Dr. Nirmala Dayal, Madam, to introduce our chief guest, none other than Honorable Justice Mahendra Parikh sir. Over to you, ma'am.
Thank you, Rajesh sir. I know you had many programs today, but sparing your invaluable time for us. Thank you.
Please excuse me. Thank you.
And we understand, sir. Thank you. I have the honor and privilege of welcoming our chief guest, Mahendra Parikh sir. Honorable Parikh sir was with us in our first national conference related to consumers. Today again, he has graced this occasion. A hearty welcome to you, sir. It is a true honor and privilege to have amongst us as chief guest for the conference none other than the dignified and distinguished Honorable Justice Shri Mahendra Parikh Sahib, retired judge of Gujarat High Court and former president of Consumer Redressal Commission. Justice Mahendra Sankalchand Parikh, sir, was appointed an additional judge of the High Court of Gujarat in the year 1990 and thereafter as a permanent judge of High Court in 1995. Sir was the president of the Gujarat State Commission Consumer Dispute Redressal Commission and for 2 months held charge of being both the judge of High Court and the president of the commission. A huge responsibility, sir. Justice Parikh Sahib retired as High Court judge in January 2001 and continued as president of Consumer Disputes Redressal Commission for 5 more years thereafter.
We know that sir has some other.
Rajesh sir, kindly mute your device.
Thank you. That.
Rajesh sir, kindly mute your device. It is on. Thank you. He retired from the post of the State Commission in 2006. He was also legal consultant to the Justice M.P. Shah Commission for 3 to 4 years. Sir is also an active arbitrator. However, he has stopped taking new cases now. Despite his several accomplishments, Sir has been an active sportsman also. He has played table tennis, volleyball, cricket, and badminton in his college days. Sir, હું કોઈ બીજું sports ભૂલી ગઈ હો તો પછી યાદ કરાવી દેજો. He was on cricket team of the City Civil and Sessions Court and in High Court cricket team of judges. Kudos to you, Justice Parikh, sir, for all these distinguished accomplishments, both in the court as well as the commission, as well as on the sports field and off the court also. I now request our Honorable Chief Guest for the second virtual 2-day national conference on expanding horizons of consumer rights, Honorable Justice Shri Mahendra Parikh sir, to enlighten us with his fine words. Over to you, Parikh Sahib. Thank you and welcome.
Honorable Mr. Justice Patel, Honorable President of the Gujarat State Consumer Dispute Redressal Commission, Advocate Sri Rajesh Bhai, Mr. Desai, Advocate Sri Kumar Joshi, Advocate Sri Shreyanshu Desai, all the dignitaries, and with pranams to all the teachers and gurus, I address my friends in this virtual conference with a statement that when I joined my service in the bank, while I was doing my law degree course, the general manager asked me, "What games are you playing?" And I said, "I play all the games except hockey and football." And he remarked that your physics suggests that you would not be playing hockey and football. Friends, today's conference is on the expansion of horizons of consumer rights, but this expansion has taken place in a very gradual process. And if we take ourselves to our ancient scriptures time, we'll see that it was already there in a very condensed and very healthy form. The other day I was reading Essence of Vedas and Allied Scriptures by Sri Basdev Vishnu Dayal, and I could notice certain versions from the Vedas. Atharvaved said that May everybody belonging to us be happy and endowed with auspicious knowledge. May we be seeing the sun for a long time. May welfare be to the cows, to the world, and to all men. May welfare be to our mother and father. And then in Yajurved, I have found this version. I will contemplate only sweet things and produce only sweet things. I will bear only sweet things to others, and I will talk only sweet words. And there was a caution note also in the Samved. Oh God, give us security from that we are afraid. For what? For our protection, keep away from us the vices of hatred and violence. And then you will see that the concept of consumerism was inbuilt in the all beings, all living beings, and it has expanded through the ages. Then came the era of Upanishads, and there we come across the story of Nachiketa. I will take, if time permits, to the story a little later. But then the concept of consumerism could be found in that story also. Thereafter, we go to the 20th century, where Mahatma Gandhi gave a message. And I will read out this message, and I would request all my gurus, all my teachers, all my learned friends to circulate this to the traders, manufacturers, and all service providers, because it is in their interest to serve the consumers. Mahatma Ji said, a customer is the most important visitor on our premises. He is not dependent on us. We are dependent on him. He is not an interruption in our work. He is the purpose of it. He is not an outsider in our business. He is part of it. We are not doing him a favor by serving him. He is doing us a favor by giving us an opportunity to do so. So this was the message which was given by Mahatma Ji to all the traders and service providers, so that the industry and commerce would flourish and also the consumers would be served. Then came a well-known speech by then President John Fitzgerald Kennedy, who addressed the Congress, and in his address he said, these consumer rights: 1, right to safety; 2, right to be informed; 3, right to be heard; and 4, right to choose. And then in 1985, United Nations, through the guidelines published, following rights were added: the right to satisfaction of basic needs, right to redressal, right to consumer education, right to healthy environment. And I'm happy to inform you that in our 1986 Act, the rights of the consumers were enacted in Section 6 of the said Act. But then that was not sufficient. The industry and commerce were fast developing. The technology was coming into fore, and there were several marketplaces which came into being. So it became necessary to further expand the field of consumer rights. That is how the new Act, Consumer Protection Act 2019, came into force. You'll be surprised to know that there were two classes which have been working in the society. One is the honest class, who really serve the society, who really produces good and quality goods, who really render good and quality services. And there is a class which indulges in unscrupulous practices. I am reminded of a very funny story by one Hasya Lekhak, late Vinod Bhai Bhatt. He wrote that there was a king who wanted to find out a person in his state who would be indulging in adulteration. And the minister found out one and brought him to the king. The king gave him punishment of death. The punishment was to be given by hanging. And when the trader was to be hanged, the rope was there, and when the process of hanging started, the rope broke down and the man could not be hanged. And the king asked, how did that happen? And the minister said that the rope was purchased from that very trader. That is the situation with, so far as the other side of the commerce, industry and trading is concerned. That is the reason why the new act has come into being, and I'll take you to a bird's eye view of the salient features of the new act, so that the friends who are attending to this conference will have benefit of what are the basic features of the new act. It was a long-awaited act which repealed the Consumer Protection Act 1986 and replaced new provisions. It received President's assent in August 2019. Majority of the provisions of the new act made applicable from July 2020. The new act contains many new provisions which advance protection and promotion of consumer rights. The act has not changed redressal mechanism hierarchy, but has added more powers for smooth functioning of the redressal agencies. To provide simple, cheaper and doorstep remedy, the new act has now provided that consumer can file complaint even from the place where he ordinarily resides, irrespective of the fact that cause of action has arisen there or not. This will give greater and more relief to consumers, as it would meet with inexpensive remedy at their doorstep. The act has removed concept of commercial purpose from the consumer of services, but the removal is with regard to the earning of livelihood by the service provider. You can also see that the scope of the word deficiency is enlarged through the inclusion of act of omission, commission or negligent act and deliberate withholding of relevant information. In case of minor purchaser, his or her legal representatives, legal guardians would be treated as complainants. Being mindful of present trend of e-commerce, this is very important, and direct selling, adequate safeguards have been provided, authorizing central government to frame rules in this regard. The rules so prescribed have taken enough care to see that rights to consumers are not violated through unscrupulous business entities. Thus, the market makers are not only regulated but also put under scanner so that no unfair dealing can take place, more particularly when e-commerce activity can be done from a place which may be remote place in the country. Now, pausing here for a moment, this technology has done a great service to the society. At the same time, it has added to certain drawbacks so far as the consumers are concerned. and there is a likelihood of cases coming before the consumer courts with regard to the unfair trade practices or deficiency in services. The other day I came across a decision of the Orissa State Consumer Dispute Redressal Commission. Of course, that will be subject to further proceedings. But then, in that case, the well-known marketplace was held liable where a law student's order for a laptop placed at a discounted rate was cancelled after it was confirmed. And the State Commission awarded compensation in the sum of rupees 40,000 and cost of rupees 5,000, holding that the consumer could not find out the original vendor, and it was within the special knowledge of the service provider of marketplace. But there is a divergence of opinion, and Chhattisgarh State Commission has taken a different view on the basis of the concept of privity of contract. Even in America, this process has been ongoing. In 2019, the US Court of Appeals for the Third Circuit, in the case of Oberdorf versus so-and-so, held so-and-so liable for a defective product. The case involved a plaintiff who was gravely injured when a dog leash purchased by her from a third-party vendor at the particular marketplace sprung back, hitting her left eye, permanently damaging it. Unable to locate the third-party seller, the plaintiff filed a suit against Amazon. The argument was with regard to the privity of contract between the vendor and the consumer, but that argument was rejected on these grounds. One, only member of marketing place made to locate vendor could communicate only with that vendor, allowed to conceal third-party vendors, leaving consumers with defective products with no direct recourse to the third-party vendor. Then the marketplace takes no precautions to ensure that the third-party vendors are in a good standing under the laws of the country where they are registered. Then third, the marketplace exercises substantial control over the third-party sellers and is fully capable of removing unsafe products from the website. 4. The marketplace is in a better position to protect the circulation of the product that is indemnification clause, entitlement against third-party sellers was also there in favor of the marketplace. On these reasonings, the consumer was given relief. So what is important is that with the advancement of technology, new horizons have opened for the welfare and for the safety of the consumers. To deal with the consumer's right as a class, separate body has been established, namely CCPA, Central Consumer Protection Authority, and it has been vested with adequate powers to prevent, protect, and enforce consumer rights, and if necessary to inquire into complaints of unfair trade practices, suo motu, and it can also intervene even in pending matters before the consumer agencies at any stage. The CCPA will also look after misleading advertisements and authority to seize and desist such practices. It is authorized to impose penalty and also to file complaint before the competent court for offences under the Act. Although to streamline and to avoid controversy in judgments, appeal against order of CCPA is provided before the NCDRC. To avoid delay and to provide cheaper remedy at the doorstep, pecuniary jurisdiction has been increased and district commissions are authorized to deal with matters up to 50 lakhs of rupees, state commissions from 50 lakhs to 2 crores of rupees, and NCDRC about 2 crores of rupees. The state commission and the NCDRC have been given additional jurisdiction to deal with matters of unfair contract which are detrimental to consumers' rights. The state and national commissions can declare any term to the contract which is unfair to consumer to be null and void. Non-issuance of bill to party, refusal to refund price paid by the consumer in case of return of defective goods, and disclosing sensitive personal information of consumers to others are included in the unfair trade practices. Then to safeguard interests of consumers against hazardous goods during the use, product liability, very important. There is a chapter on product liability in the new Act. Product liability actions have been included within the ambit of the Act. Higher penalty and punishment of imprisonment are also provided in case of manufacturing, servicing, and selling unsafe products, and redressal agencies are empowered to even award punitive damages to the sufferer. To overcome pendency of cases, mediation has been provided, and redressal agencies are required to assess the probabilities of mediation and to, in appropriate cases, to recommend mediation for resolution of disputes between the parties. Even partial mediation is permitted, and order passed by the redressal agencies on the basis of mediator's report is given finality through restricting appeal against such orders from mediation. From technical point of view, to avoid delay in justice and to save expenses of litigation, apex court level, second appeal has been provided at NCDRC level to minimize filing of appeal on flimsy grounds. There is provision to deposit 50% of the ordered amount as condition precedent for entertaining such appeals. Since speedy redressal is one of the objectives, even adjournment is made subject to cost. Enforcement of the orders has been made at par as if decree passed in civil court. It has also been provided for criminal actions for non-compliance. Over and above all these, this is an additional remedy provided to consumers. From the above, it can be seen that the Act has been given sharp teeth to protect the consumer rights, and that may give rise to boost economic activities. Friends, the field of consumer rights has been much expanded in the new Act. But what is important for the law students and the practicing advocates on the consumer side is to study also the provisions of the contract law, the provisions of the Sale of Goods Act, the provisions of the Sale Procedure Code. In that, even Order 21 has been made part of the execution process under the Consumer Protection Act. You have also to study the provisions of the Criminal Procedure Code, because certain offences are made cognizable, certain offences are made punishable with life imprisonment, and therefore it would be necessary to go through the provisions of the Penal Code as well as the Criminal Procedure Code. I would request all the participants to see that all-round study in the field of law is required to be made if one has to do justice to the consumers and plead their cause before the consumer courts as also the courts where the matters are taken for execution. I am thankful to all the organizers, Shri Rajesh Bhai, Madam Principal, all the teachers who are there with my pranams, and to all the friends with my best wishes and best blessings. Thank you very much.
અવાજ નથી આવતો.
Thank you so much, sir. No words are enough to thank you. And we are truly grateful for your association and being a part of this conference. Now, I request Sri Shreyas Desai, sir, leading advocate.
અવાજ નથી આવતો.
Dayal ma'am, you are muted. We can't hear you.
Okay, fine. Parikh sir, my query is કે ઓરિસ્સા કોર્ટે જે વાત કરી કે સ્પેશિયલ નોલેજ ઓફ ધ સેલર, તો બોલ્ડરી વર્સિસ માર્શલમાં તે લોકોએ બોલ્ડરીને કમ્પેન્સેશન આપ્યું હતું બીકોઝ ઓફ સ્પેશિયલ નોલેજ ઓફ ધ સેલર. તો આ વખતે છત્તીસગઢ કોર્ટે કેમ પ્રેવિટી ઓફ કોન્ટ્રાક્ટનું લીધું? Can you just elucidate?
The concept of privity of contract was highlighted.
Okay, fine. પણ precedent કઈ બીજું કહે છે સાહેબ, precedent કઈ બીજું કહે છે. Anyway, I'll look into the case and get back to you personally. Thank you. Ankita madam, over to you. Ankita.
Thank you, ma'am. Thank you, ma'am. Thank you so much, sir. No words are enough to thank you, and we are truly grateful for your association and being a part of this conference. Now, I request Sri Shreyas Desai, sir, leading advocate and former chairman of Consumer Grievance Committee, South Gujarat Chamber of Commerce and Industry, to welcome Honorable Justice Sri Vishnu Kumar Patel. Over to you, Shreyas, sir.
ઓનરેબલ જસ્ટિસ વીપી પટેલ સાહેબની ગણના ગુજરાત હાઈકોર્ટના એક બહોશ અને વિદ્વાન અને પ્રતિભા સંપન્ન ન્યાયમૂર્તિઓમાં થતી હતી. વય મર્યાદાને કારણે ગુજરાત હાઈકોર્ટમાંથી નિવૃત્ત થયા બાદ શ્રી પટેલ સાહેબ ગુજરાત સ્ટેટ કમિશનના પ્રમુખ નિમાયા છે જૂન 2021થી. એવો ખૂબ જ યોગ્ય સમયે ગુજરાત સ્ટેટ કમિશનના પ્રમુખ નિમાયા છે, કારણ કે ગુજરાત સ્ટેટ કમિશનને અત્યારના તબક્કે એક સશક્ત અને સમર્થ નેતૃત્વની જરૂરત હતી. કારણ કે મને યાદ છે, હું તો ગ્રાહક સુરક્ષા ધારાનો અમલ થયો ત્યારથી જ ગુજરાતમાં પ્રેક્ટિસ સાથે સંકળાયેલો છું. જસ્ટિસ પરીખ સાહેબનો સમય અને જસ્ટિસ આરપી ધોળકિયા સાહેબનો સમય, એ બે સમય ગુજરાતના માટે એક ગ્રાહક કન્ઝ્યુમર મુવમેન્ટ અને કન્ઝ્યુમર કોર્ટો માટે એક સુવર્ણ કાળ જેવા ગણાતા હતા. પણ કાળક્રમે પછીથી થયું એવું કે, અને ખાસ કરીને પરીખ સાહેબે લગભગ ગુજરાતના બધા જિલ્લાઓની મુલાકાત લેતા હતા અને એમણે ગ્રાહક અદાલતોને એલર્ટ રાખી. ધોળકિયા સાહેબે ગુજરાતના દરેક જિલ્લાની ગ્રાહક અદાલત, જિલ્લા ફોરમને એનું પોતાનું બિલ્ડિંગ અપાવ્યું અને એમણે પણ મોનિટર કરતા હતા. પાછળથી એક તબક્કો એવો આવ્યો કે જ્યારે પટેલ સાહેબે આ ચાર્જ સંભાળ્યો ત્યારે પ્રમુખ પદનો 19 જિલ્લા કમિશનોના પ્રમુખની જગ્યા ખાલી હતી ગુજરાતમાં, અને લગભગ એટલે 19 પ્રમુખોની જગ્યા ખાલી, 40 મેમ્બરોની જગ્યા ખાલી, અને થોડુંક જે આખું માળખું હતું ગ્રાહક અદાલતોનું, આપણે જેને અદાલત જ સામાન્ય ભાષામાં કહીએ, આમ એને કમિશન કહે છે, જિલ્લા કમિશન, તો એ માળખું જરાક કંઈક અંશે થોડું અસ્તવ્યસ્ત થયેલું હતું. એટલે એ તબક્કે, અને કદાચ ગુજરાતમાં નહીં પણ બીજે પણ થયું હશે, બીજા રાજ્યોમાં પણ, એ તબક્કે ખાસ કરીને જ્યારે એમને જસ્ટિસ વીપી પટેલ સાહેબને અહીંયા લાવવામાં આવ્યા છે અને એમણે આવતાની સાથે તરત જ આ 19 જિલ્લા કમિશનોના પ્રમુખની જગ્યાઓ ભરવા માટેની પ્રક્રિયા શરૂ કરી અને 40 જે મેમ્બરોની જગ્યા ખાલી પડેલી તે પણ ભરવાની પ્રક્રિયા શરૂ કરી અને લગભગ પૂર્ણ કરી છે. એને માટે કદાચ પહેલી વાર જ આટલા વર્ષોના ઇતિહાસમાં ઇન્ટરવ્યૂ લેવાયા અને એના વ્યવસ્થિત ઇન્ટરવ્યૂ થયા અને એ બધો પ્રોસેસ અત્યારે ચાલી રહ્યો છે. અને મને એવું થાય છે કે આ બધા મંથનને ના પરિણામે એક ગુજરાતનું માળખું ગ્રાહક અદાલતોનું છે એ જસ્ટિસ વીપી પટેલના કાર્યકાળમાં એક સશક્ત અદાલતોનું માળખું બની રહેશે એવી આપણે અપેક્ષા રાખી શકીએ છીએ. જસ્ટિસ વીપી પટેલે એમની કારકિર્દીની, વકીલાતની કારકિર્દીની શરૂઆત મહેસાણાથી કરેલી. કદાચ આપને જાણીને નવાઈ લાગશે અને આનંદ પણ થશે કે જસ્ટિસ પટેલ એક એવી વ્યક્તિ છે કે જેમણે વિદ્યાર્થીઓને પણ કાયદો શીખ્યો છે અને જજોને પણ કાયદો શીખ્યો છે. તેઓ લો કોલેજના મહેસાણાની લો કોલેજના પાર્ટ ટાઈમ લેક્ચરર રહ્યા, તેઓ મહેસાણાની લો કોલેજના ફૂલ ટાઈમ લેક્ચરર રહ્યા, તેઓ મહેસાણાની લો કોલેજના પ્રિન્સિપલ પણ રહ્યા અને તેઓ ગુજરાત રાજ્યની જ્યુડિશિયલ એકેડેમીમાં પણ પહેલા આસિસ્ટન્ટ ડાયરેક્ટર અને પછી ડાયરેક્ટર તરીકે 4 વર્ષ રહ્યા. એટલે એમણે વિદ્યાર્થીઓને પણ ટ્રેન કર્યા એક તરફ અને એમણે ન્યાયાધીશોને પણ ટ્રેન કરે એક તરફ અને એક પ્રેક્ટિસ પણ કરી અને એક પાછા બહુ પ્રતિભા સંપન્ન જજ તરીકે પણ પુરવાર થયા. એટલે એમની એક આખી જે કારકિર્દી છે એક ભવ્ય અને બહુમુખી પ્રતિભા સંપન્ન છે અને અત્યારે આખું ગુજરાત એમના પ્રત્યે ખૂબ જ આદર અને ખૂબ જ આશાથી જોઈ રહ્યું છે કે થોડુંક જે ગુજરાતમાં નબળું પડેલું છે તંત્ર, જે અસ્તવ્યસ્ત થયું છે તે હવે સશક્ત બનશે ટૂંક સમયમાં અને ફરીથી અગાઉની જેમ ધમધોકાર કન્ઝ્યુમર કોર્ટો ચાલતી રહેશે. એક જિલ્લા કમિશનો 100-175, 80-100 કેસોના નિકાલ કરતી થશે. એ તો ભવિષ્યમાં વીપી પટેલ સાહેબનો કાર્યકાળ પણ એક સુવર્ણ કાર્યકાળ તરીકે યાદગાર અને અમર બની જશે એવી અત્યારે આશા રખાય છે. હું જસ્ટિસ વીપી પટેલને આપણા બધા વતી આ કાર્યક્રમમાં હૃદયપૂર્વકનો આવકાર આપું છું. અમારા આમંત્રણને માન આપીને તેમણે તરત જ આ કાર્યક્રમ માટે આવવાની સંમતિ આપી. કારણ કે મને ખ્યાલ છે કે એ જ વખતે આ બધા નિમણૂકોનો ને એપોઇન્ટમેન્ટનો પ્રોસિજર શરૂ થઈ ગયેલો હતો જિલ્લા કમિશનો માટેનો, છતાં પણ એમણે એમાંથી સમય કાઢીને તરત આ પાડી. એટલું કંઈ પણ એમણે કહ્યું કે ભવિષ્યમાં કોઈ વાર તમે ઓફલાઈન રાખો તો પણ એમને એ આવવા માટે એમણે તૈયારી બતાવી છે. પણ આ બધું કોવિડ ને બધું ચાલે છે, પણ એ એકવાર જો શાંત થાય તો એકવાર આપણે એક મોટો કાર્યક્રમ પણ રાખીશું જેમાં એમને ફરીથી ઓફલાઈન કાર્યક્રમ હોલમાં રાખીશું અને એમાં એમને પટેલ સાહેબને બોલાવીશું. તો હું પટેલ સાહેબને આભાર માનું છું એમનો કે આપણે આમંત્રણને માન આપીને તેઓ આ કાર્યક્રમમાં ભાગ લેવા સંમત થયા અને હું એમને હૃદયપૂર્વક આવકાર આપું છું. જસ્ટિસ પટેલ સાહેબ.
ખૂબ ખૂબ આભાર શ્રેયસ દેસાઈ સાહેબ. આપે ઘણું બધું મારા માટે વધારે કહ્યું છે. હું એને લાયક બનવા માટે પ્રયત્ન કરીશ. જે કંઈ પ્રયત્ન કરીએ છીએ એ બધાનો સહિયારો પ્રયત્ન છે અને એના લીધે થોડું કંઈક ગતિ આવી છે. ઓનરેબલ જસ્ટિસ શ્રી મહેન્દ્રભાઈ પરીખ, retired judge, High Court of Gujarat, and former President, Gujarat State Consumer Dispute Redressal Commission, Sri Rajesh Desai, Chairman, Sarvajanik Education Society, Professor Percy Engineer, First Provost, Sarvajanik University, Learned Senior Advocate of Supreme Court, Sri Sukumar Podjoshi, Sri Shreyas Desai, Chairman, Administrative Committee, Law College, Dr. Armala Dayal, In Charge President, Law College, Surat, Learned Speaker, Dr. Vikram Desai, Dr. J.T. Desai, Dr. Apurva Pathak, Dr. Manisha Shukla, Dr. Snehas Bilimora, professors, dear students and participants. Good morning to all of you. First of all, I congratulate to organizer for arranging 2 days national conference on expanding horizon of consumer rights. I am told to address on consumer rights. I will share my little experience on the subject. We all know that the Consumer Protection Act 2019 came into force with effect from 20th July 2020 by repealing and replacing old Consumer Protection Act 1986. At the outset, I want to draw your attention towards the United Nations Guidelines for Consumer Protection. The United Nations Guidelines for Consumer Protection are a valuable set of principles that set out in the main characteristic of effective consumer protection legislation, enforcement institutions, and redress system. It has recognized consumer rights, bearing in mind the interest and need of consumer in all member states, particularly in the developing country, recognizing that the consumer often face imbalance in economic terms, education level, and bargaining power. In view of that, consumers should have the right of access on non-hazardous products as well as right to promote just, equitable, and sustainable economic and social development and environmental protection. These guidelines apply to the business to consumers and that B2C transactions, including the provisions of goods and services by the state enterprise to the consumers. The guidelines were first adopted by the General Assembly on 16 April 1985. Later on, it was expanded by Economic and Social Council on 26 July 1999. Thereafter, it was revised and adopted by the General Assembly in resolution dated 22nd December 2015. The 7th United Nations Conference, which was held in Geneva from 6 to 10 July 2015, adopted this revised United Nations Guidelines of Consumer and Consumer Protection by unanimously in its resolution. Consumer Protection Act 2019 has been enacted to provide a more robust grievance redressal mechanism for protecting and enforcing consumer rights, keeping in mind the first challenging new age economy, e-commerce platforms have now been specifically included in Consumer Protection Act 2019. A provision for promote and protect the consumer rights was made available in the Statement of Objects and Reasons of the old Act, CP Act 1986. The Statement of Objects and Reasons are attached to the bill, which describe the object, purpose, and reason for the bill. It also gives understanding of background and the antecedent state of affairs and the object of the law seeks to achieve. External aid and the external aids are the aids which are not available inside the statute but outside the statute. The court may seek help of the external aids in case of repugnancy or inconsistency in this statutory provision. Thus, consumers' rights were available in the statement of objects and reasons for interpretation of provisions of CP Act 1986, but now it is a statutory provision under the CP Act 2019. A consumer rights are defined under Section 2(9) of the CP Act 2019. Before that, I want to draw some, there are 6 rights under the definition. The right to be protected. The first right is right to be protected. For this, I want to share one small story that one person who was frustrated in his life by several failures, he has decided to commit suicide. He goes to the market and purchase some pesticide, poisonous items, and came to his house. He take it. He has consumed such poison, but he was failed to. He has not achieved his goal. That is that he is not dying. He has to suffer something, and thereafter he is alive. After some time, he realized that I have committed suicide, but it was failure due to some reason, and therefore he was enjoying his life. After some days, he goes to the market, he purchases ice cream and take home. He consumed the ice cream and he suffered from food poisoning, and thereafter he was died. Meaning by that, the person who purchased a drug or a poison is also adulterated. So, and person who has purchased the ice cream or a consumable item, it was also adulterated, where the consumer may go. This is the reality of the society. Therefore, consumer rights have an important role. The first right is the right to protected. It can be said right to safety. It means right to be protected against the marketing of goods and services which are hazardous to the life and property. Before purchasing, consumer should insist on the quality of the product as well as the guarantee of the product as well as services. The second right is the right to be informed. Right to be informed means they aim at providing information about the quality, quantity, potency, purity, standard, goodness, and cost of the goods to the consumer against the unjust trade practices. Without knowing the exact quantity, quality, purity, goodness, and standard of the goods, the consumer will not be able to make right decision. In a recent judgment, Joint Labour Commissioner and Registering Officer versus Kesar Lal, 2020, Supreme Court cases online, Supreme Court page number 327, it was held the beneficiary of the statutory welfare scheme was entitled to remedies under the Consumer Protection Act. The issue was decided that where the worker who is registered under the building and other construction work are the beneficiary of the scheme, and the consumer commissions have right to deal with this cases. In another case, Pioneer Urban Land Development, Urban and Infrastructure Limited versus Govind Raghavan, 2019, 5 Supreme Court cases, 725, a division bench of Supreme Court has held that the agreement between the builders and the flat purchaser constitute an unfair trade practice falling under Section 2R of the Act, and such agreement cannot be sustained. It amounts to an unfair trade practice. The third right is the right to be assured. It can be said right of choice. Consumer is assured to variety of goods and services under this right at the competitive price. In oligopoly market, consumer is not free to choose the best of for herself or himself. It includes the right of basic goods and services. However, consumer is exploited despite the rights given to him, like supply of electricity, roads, public transport, etc. Somewhere, the consumer has no choice to get the option. The fourth right, right to be heard. The right aim to provide consumer simple and speedy trial so that their problem can be solved immediately. So far as the new act is concerned, pecuniary jurisdiction has been raised, so he can get the rights at the district level. The another amendment is that the consumer can file his complaint at the where he is residing or doing his business. So long as time taking trials prevent consumers from taking action. So the procedure is also devised that it can be cut the time for long cross-examination and another things. Right to represent in courts and forums made for the consumer welfare is also included in this right. Another amendment, e-Dakhal software for online filing of complaint, as well as there is a provision in the Act for virtual hearing by video conferencing. This facility are made available by the National Informatics Center, NIC. The fifth right to seek redressal. Right to fair settlement for the loss of consumer is contained in this right. Complaint for the loss must be filed by the consumer. Grievance, either a small or big, it affects the society at large. For right to seek this redressal, there are certain amendments in 2019 Act, such as the execution of order can be made by the two ways. Civil court has right to implement its order by only the provision provided under the section under the order 21, but consumer can make an application as a civil right or as a in a criminal remedy. Under section 71 of the Consumer Act, the order 21 is applicable, fully applicable to implement his order. And if he choose to take remedy under the criminal procedure, so under section 72, he may apply to the court under the section 72. So both the remedy are available, criminal and civil, for right to seek redressal. In one of the case, Aero Grants Relatec versus Abhishek Khanna 2021 Supreme Court cases online, Supreme Court 14, a 3-judge bench has decided that the developer challenged the decision of NCRTC, wherein refund of the amounts deposited by apartment buyers was directed on account of inordinate delay. So Supreme Court has ordered to give refund by observing that there are one-sided terms of agreement in the buyer's agreement, which was treated as unfair trade practice. The sixth right is the right to consumer awareness. Here, during the first presidential address, it was said that the college have a logo or a slogan about Tamsoma Jyotirgama. So this is also a things where the light can be thrown to the person for his knowledge. This right talks about the awareness, skill and knowledge which are needed to consumer in order to make correct, valid and assured choice about the goods and services. The consumer should be aware of a basic consumer rights and duty, and at the time the knowledge of rights is important to become a sophisticated consumer. Ignorance of consumer, particularly of a rural consumers, is mainly responsible for their exploitation. If the consumer can be aware about their rights, he can definitely achieve his best interest. The Supreme Court has evolved the law on the consumer jurisprudence, and that is why the provisions of new act is also embodied. Who can take action for violation of consumer rights as a class? The consumer rights are defined, not only defined, but also it confirms the consumers' rights to be implemented by the authority. The Central Consumer Protection Council, State Consumer Protection Council, District Consumer Protection Council to render advice on promotion and protection of the consumer rights within their respective jurisdiction. Such a way, the another authority, that is Central Consumer Protection Authority, is also established under the new act to regulate the matters relating to the violation of consumers and to promote, protect and enforce the right of the consumers as a class under section 10(1) of the 2019 Act. The district collector is also empowered under section 16 to inquire into or investigate the complaints regarding violation of rights of consumer as a class on the matters relating to the consumer rights violation within his jurisdiction on a complaint or by the reference made by the central authority or the commissioner. He will submit his report to the central authority or commissioner. There are certain authorities and the authorities can file a complaint to the consumer commissions. What are the powers under the Consumer Protection Authority for violation of the consumer rights? So there are certain provision by which the consumer central authority have power to inquire or cause to inquire the investigation to be made in the violation of consumer rights. The consumer central authority may take action suo motu or on a complaint made by any person. It has also authority to file complaint before the district commission, state commission or a national commission as the case may be. The consumer can be protected by the central authority if it find in any proceeding, so they can intervene in the proceeding pending before the District Commission, State Commission, and National Commission also under Section 18(2)(c). They can also review the matters relating to the violation of consumers' affairs. There are another powers to the central authority also. In the last, the new Consumer Protection Act 2019 has expanded the horizon of the consumers to keep pace with the growing technology, where certain changes are required. Consumer Protection Act means protection of consumer from all the unfair trade practices. Hence, to comply with this said ideology, amendments are must. Earlier Act has provision with the respect of scenario of that time, but now avenues have taken different directions. This Act will more effective than the previous one and will assist the consumers in possible way with the intent of safeguarding the interest of the consumers across the model and modern age. 2019 Act aims to transform the jurisprudence pervading consumer protection from caveat emptor to a caveat venditor. Let the buyer beware to the let the seller beware. Amongst all of these, the most important is that everyone involved in the transaction other than the consumer will have to be more careful and caution than ever before. Thus, the achievement as the consumer is a king can be achieved by the provision of new act. At the last, I thankful to all the organizers by giving me opportunity to present my views before the August gathering. Thank you very much.
Thank you so much, sir.
Thank you, sir, for such an insightful address to the session. Now I would request Professor Shri Percy Engineer, sir, who is a distinguished academician heading Sarvajanik College of Engineering and Technology, Faculty of Architecture, Surat as principal since 2009. He is also the he also has the unique distinction of being the only architect in the country to serve as principal of an engineering college with 10 disciplines and 4,000 students. He is also former director of Sarvajanik School of Interior Design, and now Professor Percy Engineer Sir has been appointed as the first provost of Sarvajanik University. Sarvajanik University has been established by Sarvajanik Education Society in June 2021. He is the ex-dean of the architecture faculty as well as past member of the Senate of VNSGU. He is on the Board of Studies for Faculty for Architecture and Planning at Maharajas Sayajirao University, Vadodara. He is also a member of Board of Studies, Faculty and Governing Council of Architecture, Institute of Kanpat University. He is the past chairman of the Indian Institute of Architects Surat chapter and the Institute of Indian Interior Designers Surat regional chapter. Over to you, Percy, sir.
Thank you very much, Dayal ma'am, for inviting me. And here I go. Good morning, all the participants, experts, and speakers of the national conference today. Shri Rajesh Bhai Desai, the chairman of SES, Honorable Justice Shri Mahendra Bhai Parikh, Honorable Justice Shri Vishnu Kumar Patel, Advocate Shri Sukumar Patjoshi, Advocate Shri Shreyash Bhai Desai, Advocate Shri Kamlesh Bhai Patel, and Principal Dr. Dayal Madam. It is indeed a matter of great pleasure that VT Choksi Sarvajanik College of Law has organized this national conference on expanding the horizon of consumer rights. As rightly said by Frankfurter, the law is what the lawyers are. I repeat, the law is what the lawyers are, and the law and the lawyers are what the law schools make them. So I extend my congratulations to the Law School of Sarvajanik College of Law for organizing a very important deliberation program on this relevant topic. Friends, I'm an architect by qualification and practice, and therefore, it is right from our education and practice, we are always taught that we are supposed to break all rules. We are taught that don't limit yourselves in any set rules or paradigms. And that makes me so nervous that today I'm invited to speak in front of eminent lawyers, advocates, and Honorable Justice of Gujarat High Court and Supreme Court of India to speak on law. But friends, I understand today that if we are being able to build this safe society, it is only because of the lawmakers and the law keepers, that is the judiciary. And therefore, I consider it as my privilege today to address this galaxy of leaders from the legal fraternity, the judiciary, the bar, and the field of legal education. We are all consumers, from the obvious necessities we purchase daily to how we connect with the world with our mobiles. We consume every day in every part of our lives. All people have right to access to safe goods and quality services. Of course, to be treated fairly and to be offered effective solutions if things go wrong. And it is the Consumer Protection Act that aims to ensure that interests of consumers are secured, that timely and effective settlements of disputes take place, and competent authorities are set up for justice and dispensation. From the day President Kennedy outlined the vision of consumer right to the Congress in 1962 to this year of 2022, where we live in a transformed world, the old paradigms of consumer and service provider or client and manufacturer paradigms have changed completely. With rapid globalization, boundaries of nations have become insignificant in trade and businesses. A large number of foreign investors and service providers have capitalized on India's potential as a large market for consumption and labor, be it information technology, insurance, banking, infrastructure, and of course, all retail sectors. With increased flow of goods, services, and data across the border, it is inevitable. And of course, it is inevitably leading to interchange of knowledge traditions. This process has important implications for law and its affiliated practitioners. This transboundary economics give rise to litigation also, and we are witness to the global litigations that goes on across companies and governments. So today, consumer rights are no longer restricted to making sure that your new TV won't break down after 3 months, or the new car that you have purchased has the same features and technology as advertised, because all this is now so obvious. But today, it is important that an insurance clients need to ensure that the data collected online by the insurance company is not stolen and misused. That means the whole paradigm of consumer rights have shifted from the product to the information that he has provided to the products giving company. That the e-commerce giants deliver on rosy promises given to the buyers. That an international supply chain disruption losses are also reimbursed. Friends have rightly said, there is no perfect justice, just as there is no absolute in ethics. But there is imperfect justice, and we know it when we see it. So taking consumer protection a step further, we need also to deliberate on artificial intelligence and consumer. The future of any new technology lies in the regulations that governs it. It needs a strong legal framework around it and to explore maximum benefits. So we need technological regulators now, my friends, and not just consumer protection for products and services, but we actually need very strong technological regulators. Laws to control artificial intelligence actions as well as accountability of errors. I'm sure that the distinguished legal fraternity that we are having present today in this 3-day conference will play a key role in elaborating the widening ambit of Consumer Protection Act 2019 and in drawing attention to the lacunae. And in the last analysis, my friends, our every right is only worth what our lawyers make it worth. I repeat, our every right is only worth what our lawyer make it worth. And so I'm sure our distinguished legal experts will make it worthwhile today in their deliberation. With this, I wish the team VT Choksi Sarvajanik College of Law and all participants a lot of success for this program. Thank you very much for inviting me, and thank you for the opportunity to talk to you all. Thank you so much.
Thank you, sir, for gracing this occasion. Thank you so much. Avni ma'am, please take over.
Yes, ma'am. Yes, ma'am.
I think Avni ma'am is having some connectivity issues. Is it sorted out, ma'am?
Yes, ma'am. Yes, ma'am.
Madam, there is some echo. I'll take over. Thank you, Percy sir, for your kind words and very informative session. Must say, લાગ્યું નહીં કે તમે law fraternity ના નથી. You are a very good orator. Welcome, sir, and thank you so much.
That was what was making me nervous, because as an architect, to speak in front of the legends of law, it is indeed very scary. But when listening to two Chief Justice of the law, I realized that it is so important that your contribution is actually making us safe as a habitable society. So I must thank you all, the lawmakers and the law keepers of the country, for giving us.
Do not worry. Do not worry. When I started my practice, my senior used to tell me that law is an ass. You have to hit it to get justice for the righteous person.
Right. But sir, I was searching for the lawmakers and I found a very nice quotation, that there are only two people in front of whom everybody confesses honestly. One is when he is standing in front of the God in a temple, and the second one is his own lawyer. These are the only two people who in front of whom he would confess honestly. And therefore, I would put you today in the place of God as this workshop goes on. Thank you.
Very well said. Thank you, sir. Thank you so much. Thank you, Percy, sir. Now, concept note by our guest of honor, Advocate Shri Sukumar Patjoshi, sir. Avni ma'am, can you take over?
Yes, ma'am. Yes, sure. Thank you so much, sir. Now, a concept note by our Honorable Advocate Shri Sukumar Patjoshi, Senior Advocate at the New LLB from Campus Law Center, University of Delhi in the year of 1986. Got enrolled with the Bar Council Delhi as an advocate in early 1987 and started practice in Supreme Court of India and various high courts at the tribunals, mainly in the constitutional, commercial, criminal and the civil laws. He has been designated as a senior advocate. His contribution to the welfare of the legal fraternity has also been recognized by the lawyer who have elected him to the Executive Committee of the Supreme Court Bar Association for the 3 times, including as Vice President of the Supreme Court Bar Association in 2018. He is also a postgraduate in the social work and actively engaged in the development sector and have worked for the welfare of the victims of the crime and an active votary of the sustainable development and the biodiversity. As regard his practice is in National Consumer Dispute Redressal Commission and Supreme Court dealing with the consumer related laws are concerned. He is a senior counsel of the Supreme Court of India and the National Consumer Dispute Redressal Commission. Over to you, sir.
Honorable Justice Sri Mahendra Parikh ji.
Sorry to interrupt you, sir. We cannot see you. We can only hear you, sir. Kindly switch on your camera if possible.
My camera is on and I can see myself in the screen.
None of us can see you, sir.
What do I do? Camera is on.
No, we can see. I can see.
Okay, okay, fine. Then there's something. Okay, I can see you now, sir. I can see you. Please
I
continue.
see. Maybe that, my presence is so small. Amongst the giants, I am a dwarf. So obviously you can't see me.
Sir. No, it's not like that. Please carry on. Sorry to interrupt.
Right. Honorable Justice Parikh, former judge of the High Court of Gujarat and Honorable President of the State Commission Gujarat, Justice Patel, Honorable Judge of Honorable former Judge of High Court of Gujarat, and the present Honorable President of the State Commission of Gujarat, Shreyas Bhai Desai, Dr. Dayal, and other dignitaries. The advantage of speaking little late after the giants is too many, and particularly if you are in the role of guest of honor, because most of the technical part and difficult part has already been spoken, so that my life is easier. And particularly after hearing Mr. Percy, it is so enlightening and enriching to us. In fact, I think Justice Patel and Justice Parikh will agree with me. Somebody who supposedly has nothing to do with the practice and profession of law is so erudite and could conceptualize this concept. I think it's a step to be happy about. Today I have been asked to give a concept note, and luckily for me that Justice Parikh and Justice Patel have already given very in-depth lecture on the Act itself and what it provides for, what is the change, and including judgments of the Supreme Court. I'll give a concept. In fact, as a concept, consumer protection in India as a practice symbolizes, I think, the human values and traditions. And in fact, this is as old as the Indian civilization is. In the earlier part, as a part of the welfare for the subjects, the rulers, in fact, this is known through history, not very far, always impose restrictions on unfair trade practices, that is, to safeguard the interest of the buyer. See, the concept was already old and concept is ancient. Justice Parikh also took you through the Vedas, and from there you see that in ancient India, the Vedas were, even now, are considered as words of gods. And sir has rightly pointed out that in Dharma Shastras and Vedas, the concept of consumer protection finds mention. And you can relate. So therefore, this is age old and we have grown with this. Today, in the present day context, as we know, we all live at a time and space when almost everything can be bought and sold. In fact, you would have noticed sometimes that somebody shaves his head and gives an advertisement of an airline. So therefore, even your body space can be bought and sold for various commercial ventures. So in this kind of a thing, when the liberalization came in the early 80s, it was thought that it will be good for the consumers. Particularly in Indian sense, I'll say this, that we are used to be dependent on buying one car. If one wants to buy a car, he had choice either a Fiat or an Ambassador, and both were equally bad. Similarly, a telephone connection was considered very luxurious, and there was no choice. So with the liberalization, different models came and phone companies came and things like that. So that with that, we thought that substantially the freedom of the consumer regarding choices will substantially improve. And we thought that the market and market values govern the lives of the people. But the liberalization had its own evils, that the markets, as it opened up with the deregulations of 80s and 90s, noticed that even education, health, etc. became more of a marketing items than of for the purpose it was there. And it was the market morality went down, that people tried to make gains by unfair means, even by with the business of education and health. So then it was thought that there should be some regulations, at least to curb all this. Otherwise, liberalization would have been a answer to all and a panacea for solving, because there will be a choice. If you do not like Airtel, you go to Vodafone, and you have a choice. So that is enough threat for one company that the buyer will move. So over the years, the faith in the market is in doubt. And that's why the significance and the concept of consumer protection has gained currency. It is also a fact known to all of us, as we all are consumers. The largest investor for any product in the world is the consumer. Because the products are aimed at this. Unless the consumers put in money, the products can't take shape, can't be manufactured, can't come to the market, and no purpose thereof would be there. And therefore, it is natural that the product manufacturers, sellers, and service providers should be subservient and dependent on the consumers. But ironically, it is seen the consumer is weak. After being the largest investor, it is the weakest link in the consumer chain. You just see, may it be the real estate, electricity, transport, anything. If some entrepreneur wants to do that business, he aims at who are the consumers, how many, what is the numbers, how much is my gain, who will be the segment eyeing on me, etc., etc. So everything revolves around the consumer. Consumer is the fulcrum of any activity. And yet it is seen that the consumer is weaker. And this is where I say why there is a need for rules, regulations, and a consumer protection to be devised by the state. The objective to protect consumer from, the objective of consumer protection is primarily two. Firstly, to save them from being offered inferior products of goods and services. And secondly, the products being offered at exorbitant price, which is unrealistic. And by both of these, the society and the nation and the national economy and health and development status is affected. That's why there is a need for the government intervention. Otherwise, this is a private thing. So both, you don't need it. It's a buyer and seller. Why the consumer is weak? It is because of the bargaining power. Bargaining power of there are two sides to one product. One is a manufacturing buyer supplier side, and the other one is the consumer side. The problem is that the bargaining power is always more with the supplier side because it has more information which it conceals. It has more capacity. It has regulated people. Say, for example, legal. There will be a team of lawyers who will be devising what should be our warning, what should be the package containing, what should be the labeling, many things. Whereas the consumer is, though they are collectively so many, but they are individuals, they don't have the wherewithals to check that whether this product is safe, whether this product is good for me, whether it is at a good price, whether it is value for money. They don't have the wherewithals to examine those. So therefore, naturally, he is in a lower position in the bargaining transaction. And to curb this, the state regulates primarily for 4 reasons. The regulation is to regulate the supplier side to engage in fair competition. That is, first I said that if fair competition is there, maybe there will be choice, and then the bad things will be cycled out. Something, if an inferior product or at a higher price will be cycled out by competition itself. To provide full information of their products so that something is good or bad, the consumer will have a right to determine. Then observe all laws regarding safety and quality. So this also, the purpose of regulation is this. And last one is very important, which the Consumer Protection Act has really made it a reality, is compensate consumer if problems arise with their product. So these are the 4 things why a regulation is needed. The logic and philosophy behind developing laws of consumer protection in modern times can be analyzed from the 3 aspects or on 3 steps. What is the need and rationale for consumer protection in modern times? As I said, that the disparity exists, and to minimize the disparity, there is a need. So they need to bridge the gap in terms of bargaining power, in terms of knowledge, in terms of resources. So it is provided, the only philosophy is to provide equilibrium of bargaining strength of demand side and supply side, and to ensure a safe marketplace for consumers. Safe is further would require a lot of interpretation. Then what is the mechanism for bringing about the equilibrium and ensuring a safe marketplace? The objective, as I said, is to protect the consumers from being offered inferior products at exorbitant price. Now I'll say that my previous speakers have already spoken about how it developed and etc. So I'll not go into that, and this is not desirable to go into all those. The students should be studying those. how the Bill of Rights came, and from there it all generated the Gandhian concept of consumer, etc. I'll just touch upon the Consumer Protection Act now, and why there was a need for total overhauling of the consumer law, repealing the earlier Act of 1986 and bringing about a new Act. The earlier Act, that is 1986 Act, was an excellent foundation for better protection of interest of consumers. As you take from the new Act's preamble, probably this will provide a speedier things. The only lacuna in that Act, of course, like Percy said, that it depends on the lawyers and the persons who function at the helms of affairs to execute the law and enforce it. The earlier Act, the major lacuna was delay in disposals. That is linked to many and various reasons. We are not going to analyze that in an academic conference. And also because of the advent of electronic marketing and the offline online marketing, etc., which was not envisaged in the earlier Act. The reach of the market was more, so the scope has to be enlarged. Except for that there was a lot of pendency, and it was not, the disposal was a problem. Like Justice Patel says that here, even adjournment, there has to be a cost, and filing appeal is discouraged by making it mandatory that you have to deposit 50%. So those steps came in the new Act to regulate. Then Justice Patel cited about seven judgments. They all have been taken note of by the Parliament. And in fact, they have made, like unfair trade practice, it was in Pioneer Urban said, and Abhishek Khanna, it was said there. Those things are a reality. Justice Goel's judgment has been translated into that mediation chapter. So these are all taken from the Supreme Court's also the reflections in various judgments. And this has now come. I'll just quickly touch upon the features of the new Act. The definition has been increased. The definition of the consumer has been enhanced, and the scope is much more. And that includes, in the expanded definition, includes persons who engage in offline or online transaction through electronic means or by teleshopping or direct selling or multi-level marketing. In the transactions concluded in all media in any case covered under 1986. So this is a improvement and enhancement from there. Now this definition also provides remedy in case of multi-level marketing or any problems arising out of grievance arising out of. So there is no, and also it is not restricted only to the direct those grievances, say defective goods, etc. So if the defective goods now gives rise to some other losses, say for example, you have bought a gas stove. So earlier Act, could provide only that if the gas stove was defective, it will be replaced or you'll get the money for that. But now if the gas stove, because of the defect, explodes and causes a bodily injury, or a fire occurs in the house, those are also in the category of product liability, they are covered. So that is a new ground. And now so I'm not touching in great detail. There are 2 new grounds for filing appeal. Earlier, there were roughly about 6 major grounds on which you could file a complaint. Sorry, not appeals, file complaints. Now, 2 majorly, one is in fact that introduction of unfair contracts and expanse of unfair trade practices. This is one very peculiar and new. This has given this new ground of filing complaints. Purely that the clause itself was unfair, etc. And in the previous legislation, the complaint could be filed only if an unfair trade practice or a restrictive trade practice was adopted by any trader or service provider. But now unfair contract has also been added, with which further broadens the grounds to file complaints. Then also in the I'll just give you a few, about 5 of those points. Service provider on one hand and the consumer are having such terms which cause significant change in the rights of the consumer. Which are the changes? Just see. Now it requiring manifestly excessive security deposits. That's an unfair clause contract. The law takes note of, to be given by a consumer for the performance of contractual obligation. That has been noticed. Imposing any penalty on the consumer for the breach of contract thereof, which is solely disproportionate to the loss occurred due to such breach of, like in real estate. Shreyas bhai, you have done those cases where if there is a delay in payment of one installment, there will be 24%. But when it is the builder has to give it, it will be 6%. So those things. Refusing to accept early repayment of debts. In banking parlance, you have got the award for that, so you know it better. Refusing to accept early repayment of debts on payments applicable penalty, or entitling a party to contract to terminate such contract unilaterally without reasonable cause. Permitting or having the effect of permitting one party to assign the contract to detriment of the other party. Like, these builders, they say that rights I have sold, risks I have sold. So those things also you can come. Imposing on the consumer any unreasonable charge, obligation or condition. So these are the 5 things on which are unfair contracts which can be brought about. Then a second thing is the unfair trade practice has been expanded. In 1986, it listed 6 types of unfair trade practice. And 3 additional types of unfair trade practice have been added. So they are in fact failure or non-issuance of a bill or a receipt or a cash memo, refusal to take back or withdraw defective goods. This is, well, when you travel to England or any part of the Europe, that was a done thing, that you bring something, try, and then you take it back. Nobody will ask questions. But here, they were not taking it back. Now, particularly now with this online, Amazon, all these things, they deliver. You have no way of checking the method. In fact, the delivery boy will say that I'll not show it to you, opening. So this was much more important. So this is in that right, refusal to take back. So these are 2 unfair trade practices added. The third one is disclosure of consumers' personal information. Sir has already said that, which in fact Supreme Court has noted also. Now, many people, they take your personal information, and data is the new oil. So they sell it. It has that itself is a product. The disclosure of consumers' personal information to any other person, unless such disclosure is made in accordance with the provisions of law for the time. So that is also an unfair trade practice. That is a change. Then I'll just elaborate a bit. The provision give the clarity whether information can be shared if consent is. This is the low side of that. That the act should have been a little clearer. I'll come to that, the problem part. I have enlisted what are the problem areas in the new act. So I'll come to that while I finish this. Then the product liability, I just was giving, I'll expand. That is also, there is, in India, there is no separate legislation governing product liability till now. Though it was addressed under CPA 1986, and also some Supreme Court judgments are there, that indirect losses, etc. If the parties were included with the ambit of consumer, insertion of product liability as a separate chapter in 2019 Act and a new ground for filing a complaint has been one of the most significant addition to that. This provision is under Section 2, subsection 35 of the Act, allows a person to make a claim of product liability against such manufacturer, seller. I'll just come to that. Who can be made liable for product liability? That is what is defined. And chapter 6 deals with that, and that's very detailed. What are the ingredients for filing a complaint with a grievance of product liability? There could be, the grievance is firstly against 3 categories. It can be against, a cause can be brought against a product manufacturer, a product seller, or a product service provider. So there are 3 characters against whom it can come. So far as product manufacturer is concerned, when it can be filed? If the it contains a manufacturing defect or a defect in design. So the manufacturer will be liable if there is a defect in this. Or if there is a deviation from manufacturing specification. If the product is specifies something, but the product turns out to be something else. Or it does not conform to the express warranty. Or fails to contain adequate instructions to correct use. Like sir was saying that if you buy a eye drop, which has to be stored in particular or used in particular way, if that instruction is also incorrect, then also you can, and because of that some accident takes place, then you can.
Nimisha, switch off your mic.
So I'll add this product liability. Absence of then the product seller. And in that the manufacturer, one thing also made clear in the Act, the manufacturer, cannot, plead that the warranty is not given by me or that it is. So those frauds also are taken care of there. Then about product seller, who is not a product manufacturer, he can be held liable if he has exercised substantial control over the designing. It was not but designing seller said that no, according to my test, you do it. Testing, manufacturing, packaging, labeling, etc. If it was done and there is interference by the seller, seller's liability will come. He has altered, modified the product, and such alteration or modification was substantial factor in causing the harm. He has made an express warranty of product. If the seller himself also says that, independent of any express warranty made by the manufacturer, and such product failed to conform to the express warranty. Then the fourth kind of thing is regarding the seller. Product has been sold by him and the identity of product manufacturer or product is not known, because it's a principal to principal and he has to disclose who is the manufacturer. If known, the service notice or process of warranty cannot be affected on him. He is not subject to law which is in force in India. If any pass to be, so that is if the manufacturer is elsewhere and he has taken and given all these things, that he will be liable for this, the seller. He failed to exercise reasonable care in assembling, inspecting and maintaining such products. He did not pass on the warning or instructions of the product manufacturer regarding the dangers involved in this. Then the third one is particularly the liability of a product. Why I'm spending some time here, because this is a new concept of product liability. the product service provider also will be liable. If the service provided was faulty or imperfect, deficient or inadequate quality, nature and manner performance, which is required to be provided by under law for the time being in force or pursuant to any contract otherwise, or there was an act or omission or negligence or withholding of information which caused harm. The service provider did not issue adequate instruction. So if a service engineer come to install and things like that, and he's an independent agency, because his job to also familiarize you with how to use the product. And if not, then he'll be liable. Then what are the exclusion in that I need not go? Then the second important, which was not there at all in the earlier act, is the introduction of Central Consumer Protection Authority as a new regulator. This is you may wonder why, if there is already an adjudicating forum, CETA, then why there is a need for this. In fact, this will cut, if this is put to practice, this will in fact cut down many litigations, because this has the power to do that class action things, etc. and so moto. And the beauty of this is, between court and this is, that they can call for evidence from the erring manufacturer or seller or something. They themselves can do that. Whereas in the court of law or forums or commissions, the complainant will have to prove. He'll have to muster. It is his case, he'll have to prove. But here, even the evidence can be asked from the erring party itself by the CCPA. So that's the beauty of this. This will probably have a very far-reaching and beneficial thing. This is section 10, of CPA to 1906 to establish a central authority. This is to promote, protect, and enforce the rights. Let's see what are the functions mandated. The functions of this mandated is inquiring into violations of consumer rights. They can do that. Investigating and launching prosecution at appropriate forum. Passing orders to recall goods or withdraw services that are hazardous. You must be seeing that there at times some automobiles could be, there will be cases that there is a fire and some people are dying, etc. So that needs to be investigated. Or maybe a airbag doesn't open in a particular batch of cars. So those things they can ask for evidence, and then they can ban. They say that you take it out. So even if it is used for 1 year or so they'll have to return the full money and take back those products. So this is what the beauty of this new regulator. So this is passing orders to recall goods with the service that are hazardous, reimbursement of price paid, and discontinuation of unfair trade practices. This is a new role given to this CCPA, which the courts, of course, as per the act, they have, but there you have to prove, and it is a cumbersome process. Then the third function is issuance of directions to the concerned trader, manufacturer, endorser, advertiser, publisher to either discontinue a false or misleading advertisement or modify it. So if something is going on, they can immediately. Nobody need to come to them. These are all suo motu functions. Somebody can come also, they are welcome. But even if nobody is coming, it comes to their notice, they can take steps. Like as courts, we can't do anything. Unless somebody brings a case to us, we are not doing it. Then, of course, imposition of penalty is one of the functions. Issuance of safety notices, this is an important function, to consumers against unsafe goods, services, and guidelines to prevent unfair trade practices. Spread and promote awareness and research on consumer rights. Recommend adoption of international covenants and best international practices on consumer rights, etc. This is another function. And sir has already said that the district collector has also been empowered to conduct such investigation, etc., etc. Under this act, this is under this as a functionary of CCPA. Then we can see how it takes let's say, take the case of false and misleading advertisement, or how it intervenes. CCPA is empowered to take action against false and misleading advertisements. It can impose penalty of up to INR 1 million, in fact, it is there, and up to INR 5 million for every subsequent violations. That I already told you that what is a misleading advertisement, that's already there. It is important to note that such penalty can be imposed on endorsers also, thereby bringing actors, actresses in scope of penalty. However, the endorsers would be exempted from any liability if they establish that they undertook due diligence to verify the veracity of the claims before endorsing. Say, for example, there is a protein supplement and somebody advertising. If they have done due diligence that it actually does help and they believe, then that's of course, truth is the best defense everywhere. Then deletion of healthcare, this is and then certain things, this I need not deal with, sir has already dealt with that. Then about the pecuniary jurisdiction and how this is consumer friendly, that already, because now at doorstep you can come, you have the choice where you reside. You can say, for example, you have taken a medical treatment in Delhi and you have gone back to Surat, and you choose that there is some medical negligence, you can file it there itself. Or you have booked a house in Chennai and you reside there. So those things, that is at ease. And this pecuniary jurisdiction, of course, the major change was earlier on the relief claimed and the value of goods. That was section 11 of the earlier one. That has gone I must say that's an unpleasant change, because this, it will definitely, of course, that is a consumer friendly approach, no doubt, but I don't know whether the consumer fora, the state governments can be so proactive that they'll robust consumer district at district level, district commission, they can really create so much of infrastructure, etc. Because always you have seen the largest spending cases are in district forum level only. Most of the times, either they are not meant, they don't have the ministerial service at all. I had the good fortune of going to one or two district forum once in a while, just as to say some friends' cases, etc., but not to appear for any party. And there on inquiry from the presidents, they say, we have to write with our own hands only. So how many judgments can we write? We don't have a stenographer properly there. So those things, if it is improved, this is laudable. Otherwise, this will be one of these. Because, consideration paid, you just forget about the real estate. Take a note of your insurance and health care. What would be the premium? Can any case come to the state commission level? If you make the consideration paid as the basis for pecuniary jurisdiction, then whatever treatment you take will be less than 50 lakhs. You're likely to be. Whatever you have paid, that is the basis. So what is your claim is immaterial. That is, so far as theoretically speaking, is a very laudable step. And because, you can file there itself and there can be unlimited relief given by the district forum itself. So now those also by change that has been, that 10 crores has now come to 2 crores for National Commission. And for State Commission, I think it has come back to 50 lakhs, I believe, 50 lakhs and above. So those are there. Mediation is a very welcome step. And mediation, and that I was talking earlier, that use of local languages for law. This is the, I think, first process, mediation, where we can fully make it a language based also, so that the English doesn't come in the way of the mediating parties. And this mediation, though it was encouraged, of course, CPC started all these court annexed mediations, but now it has been recognized as a very good alternative dispute resolution, and that has been part of this. Otherwise, when we all, Shreyas bhai would recall, we would come to the consumer fora thinking that they are also like mediation forums, because they are aimed at resolving, finding out a solution mostly. And here there are human problems. Consumer is per se not a very commercial dispute. This is consumer dispute. So this is more of a human problems. So needs more resolution with a human approach than getting into the technicalities of law, etc. So I think this is a very welcome step in this. Quickly, I can take you to, I'm running out of time. So quickly, I say that the shortcomings would be the ambit and functioning of CCPA is ambiguous still now. In fact, there is no clarity. And as you know, even consumer fora, whether they can give interim relief, etc. or not. Incidentally, the first case of the National Commission was mine. When it was established, the very first case was mine. So I've seen the growth of the consumer cases. So earlier, till 2003, there was no interim relief kind of thing. Later on, we could give those. So as the Act came in 1986, there was no power to that. So it grows and grows. But now that is also because CCPA has for the first time come. So there is lacking clarity actually. So it must be more clear so that people can approach and avail that. And also their functioning is not very visible. Like we have court, we have addresses, you have to go, you have a registry. So we are now gentry is not really very well aware about. So that has to be. Then appeals under orders of CCPA can only be preferred before National Commission. That is again, that you are on one way you are saying that justice at doorstep, but CCPA orders can only be challenged only in the National Commission. That is one, to my mind, is little, I can't accept it. And also the grounds of appeal is not very clear. Grounds of appeal is not very clear. Then Section 12C, which prescribes how it will operate, central authority, is without any procedure. If the merits of the cases are not affected, the provisions may allow the central authority to give a go-by to the procedure, thereby impeding. So there has to be a procedure. This is a civilized legal society, so there has to be. Otherwise, it will lead to arbitrariness kind of a thing. So that's another thing. Then Section 16 and 17 I have pointed out. It seems to be overlapping powers and duties of central authority. And probably it may give rise to some intra-departmental disputes. That's my purely personal, nothing to be, this is not my comparison to this. This is my reading of the Act and the rules. And then the Section 18 to 20 has given a wide power central authority to investigate, enforce violations. The authority and powers should be restricted to investigate measures and supportive of judicial powers of the Consumer Commission. So it should be, it shouldn't be parallel. It should be supportive to our system which is existing, consumer courts. Then in Section 2, subsection 16, e-commerce, is given, means buying or selling goods or services, including digital products over digital network. The Act does not define the term digital product. So it may, you're saying that, but the digital product is not defined. This may lead to some ambiguity as to what comprises of digital product. Of course, this I have noted down that healthcare should be specifically mentioned as a service, but it doesn't, because it has all the years. It has not been there, but that is also one of the areas I would have preferred that if it is a new act coming, healthcare should have been specifically mentioned about it. Service. I think I have run out of my time. I have utilized this. It was a great privilege to be here part of this today conference. And with all these I pointed out, I think the children will do more research, they will be wrong, and the act, they'll make the act more meaningful and usable by one and all the consumers, and always, we all are consumers, so they'll add to our benefits and privileges. Thank you for giving me this opportunity.
Thank you so much, sir. No words are enough to thank you, and we are truly grateful for your association and being a part of this conference. I request Dr. Armana Dayal ma'am to welcome other dignitaries. Over to you, ma'am.
Thank you, sir, for joining us. Friends, you might not know, but sir had invited to Supreme Court today, but because of his prior commitment with us, he has obliged us. Thank you, sir. Thank you so much for your kind words. Moving further, we have amongst us former Dean of VNSGU, Dr. J.T. Desai, sir, in this gathering. Welcome, sir. We have Dr. Manisha Shukla, Principal of Bharuch Law College. Welcome, Madam. Dr. Harshad Rawal, our colleague. He is also with Bharuch Law College. A hearty welcome to you, sir. Ketna, Madam, welcome once again.
Thank you, ma'am. Thank you.
Hina Makwana, Madam, is from Law Department to
Thank you, ma'am.
Alkesh Swami, sir, a hearty welcome to all of you. So many academicians have graced this inaugural function. I heartily welcome all of you. Over to you, Nikin, sir. Kindly welcome Shreya, sir, formally.
Thank you, ma'am. I now request Advocate Shri Shreyas Desai, sir, who is in the field of practice since 1981 and columnist and writer. He has experience of nearly more than 39 years, which include more than 30 years of his experience on consumer forum and commission related matters, and has dealt with more than 10,000 cases in Surat District Consumer Dispute Resolution Forum, now its commission, and Gujarat State Consumer Dispute Resolution Commission, Ahmedabad. He has written 6 law books which have been published by leading publishers. He was also appointed as civil judge, senior division, but preferred to remain in practice. He is also appointed as panel advocate of more than 15 banks and institutions. Over to you, sir.
જેમણે ન્યાય આપવાનો છે એવા બે ન્યાયમૂર્તિઓ પરીખ સાહેબ અને પટેલ સાહેબ મારી આગળ બોલી ગયા છે. સુપ્રીમ કોર્ટ અને નેશનલ કમિશનના સિનિયર કાઉન્સિલ સુકુમાર પટ જોશી સાહેબ પણ મારી આગળ બોલી ગયા છે. I call Sukumar Pat Joshi as a Bhishma Pitamaha of consumer protection field because he is there since the beginning of implementation of the Consumer Protection Act, and bar and bench listens to him when he speaks, and he is the most sought after and most and busiest lawyer of Supreme Court and National Commission. Many times I have consulted him telephonically and he has shown me very nice solutions to the problems. Now, એટલે મારા માટે હવે રહું છે ફક્ત 1 ઓવર, 1 મેન્ડેટરી ઓવર બાકી રહી છે. 1 ઓવર મારે રમવાની છે. એટલે એમાં અને લગભગ બધું જ આવી ગયું છે. પણ પટ જોશી સાહેબ અને બંને ન્યાયમૂર્તિઓએ જે કહ્યું એ મોટા કેસોની ને એવી વાત કરી. હું થોડીક 1-2 પોઈન્ટ એવા કહેવા માંગુ છું કે જે કોમન મેનને જે અસર કરે છે. ફોરમ પાસે તો ફોરમના અમે વકીલો એટલે સુદામા જેવા, અમારી પાસે તો નાના નાના કેસો આવે. તો એ કેસમાં જે ગ્રાહકોને એકચ્યુઅલ જે મિડલ ક્લાસના ગ્રાહકોને અસર થાય છે, કઈ રીતે નવા એક્ટથી શું લાભ થાય છે, શું લાભ થયો, કારણ કે નવો એક્ટ અમલમાં આવ્યા પછી 1 વર્ષમાં સુરત ફોરમમાં લગભગ 2000 કેસો દાખલ થયા, જે નવો એક્ટ અમલમાં આવ્યા પહેલા વર્ષે 1000 થતા હતા. એટલે લગભગ ડબલ કેસો ફાઇલિંગ લગભગ ડબલ થઈ ગયું. હવે કઈ રીતે અસર થાય કોમન મેનને, હાઉ ઇટ ઇઝ એફેક્ટેડ. તો એક તો પિક્યુનરી જ્યુરિસ્ડિક્શનનું જે પટ જોશી સાહેબે અને પટેલ સાહેબ અને એમણે પણ કહ્યું કે પેક્યુનરી જ્યુરિસ્ડિક્શનમાં પહેલા વેલ્યુ ઓફ રિલીફ ક્લેમ્ડ અને વેલ્યુ ઓફ સર્વિસીસ અને ગુડ્સ ના ઉપર એટલે એના પર એનું જ્યુરિસ્ડિક્શન નક્કી થતું હતું. હવે વેલ્યુ ઓફ કન્સિડરેશન પેઇડ એના પર પેક્યુનરી જ્યુરિસ્ડિક્શન નક્કી થાય છે. એટલે કે એક માણસે વીમો લીધો હોય તો એને વીમાનું જે પ્રીમિયમ ભર્યું એ સર્વિસ એનું કન્સિડરેશન પેઇડ છે. એ જો ₹50 લાખ સુધીનું હોય તો એ ડિસ્ટ્રિક્ટ કમિશનમાં ફરિયાદ કરી શકે છે. 50 લાખથી 2 કરોડ સુધીનું હોય તો એ સ્ટેટ કમિશનમાં કરી શકે છે. અને 2 કરોડથી વધારે હોય તો એ નેશનલ કમિશનમાં કરી શકે છે. એટલે જે તમે કન્સિડરેશન ચૂકવો છો એના આધારે આ પેક્યુનરી જ્યુરિસ્ડિક્શન થાય છે. એટલે જેને આપણે જસ્ટિસ એટ ડોર સ્ટેપ્સ એમ કહીએ એ અમુક અંશે આનાથી આ એક હેતુ એટલો સાર્થક થાય છે. બીજું કે ગ્રાહકની વ્યાખ્યામાં પણ કન્સિડરેશનથી જ આવતું હતું, તો પછી પેક્યુનરી જ્યુરિસ્ડિક્શન પણ કન્સિડરેશનને આધારે નક્કી થાય એ મને પોતાને યોગ્ય લાગે છે. પોઈન્ટ નંબર 1. ટેરિટોરિયલ જ્યુરિસ્ડિક્શનની વાત કરીએ તો પહેલા ગ્રાહકે એ જ્યાંથી સર્વિસ અવેલ કરતો હતો અથવા જ્યાં સામાવાળો રિસાઇડ કરતો હોય અથવા જ્યાં સામાવાળાની ઓફિસ હોય અથવા જ્યાં કોઝ ઓફ એક્શન ઊભું થયું હોય ત્યાં કમ્પ્લેન્ટ કરવી પડતી હતી. એટલે એને જવું પડતું હતું. એ કાશ્મીર જ્યાંથી કોર્ટ ખરીદે ને કઈ ડિફેક્ટ નીકળે તો કદાચ એને કાશ્મીર એમાં ફરિયાદ કરવા જવું પડે. હવે એને સિમ્પલ બનાવ્યું છે કે જ્યાં આ પેલી જો જોગવાઈ હતી જૂની એ તો રહી જ છે, પણ ઇન એડિશનલ કે જ્યાં કમ્પ્લેનન્ટ રિસાઇડ કરતો હોય અથવા જ્યાં એ વર્ક્સ ફોર ગેમ ત્યાં પણ એ ફરિયાદ કરી શકે છે. એટલે ગ્રાહક પોતાના ઘર આંગણે જે એને સ્ટેટ કમિશન કે ડિસ્ટ્રિક્ટ કમિશનમાં ફરિયાદ કરવાની લાગુ પડતી હોય ત્યાં ફરિયાદ કરી શકે છે. આ કન્ઝ્યુમરને માટે નવા એક્ટથી આ બેનિફિટો થયા છે અને એને કારણે કન્ઝ્યુમરોના ફાઇલિંગ વધ્યા છે. હવે પટ જોશી સાહેબે કહ્યું કે કન્ઝ્યુમર ફોરમો એટલે કે ડિસ્ટ્રિક્ટ કમિશનો એટલા સ્ટ્રેન્થન નથી, પણ એ સરકાર હું માનું છું કે કરવા જોઈએ અને કદાચ એની પ્રક્રિયા ચાલી રહી છે. ગુજરાતમાં પણ મને લાગે છે કે હવે 1-2 મહિનામાં જે નવા બધા ડિસ્ટ્રિક્ટ કમિશનો કાર્યરત થશે એ વધારે સ્ટ્રેન્થન હશે, થયેલા હશે અને સારી રીતે કામ કરશે એવું મને લાગે છે. કેટલાક કેસો એવા છે કે જે નાના છે પણ જે અમે લડ્યા છે હજુ પણ ઘણાને એની ગેરસમજ થાય છે કે આવા કેસ થાય કે નહીં. આજે પણ મને 30 વર્ષ પછી પણ ગ્રાહકો પૂછે છે. દાખલા તરીકે રૂટ કેનાલ ટ્રીટમેન્ટનો કેસ. તો રૂટ પોલિસીમાં, ઇન્સ્યોરન્સ પોલિસી મેડિક્લેમમાં એવું હંમેશા લખેલું હોય છે કે મિનિમમ 24 અવર્સનું હોસ્પિટલાઇઝેશન જરૂરી હોય તો તમને ક્લેમ મળે. પણ એ જ પોલિસીમાં એક જગ્યાએ એવું પણ લખેલું છે કે અમુક સર્જિકલ ટ્રીટમેન્ટ, ડેન્ટલ સર્જરી, આઈ સર્જરી એવી અમુક સર્જિકલ ટ્રીટમેન્ટ છે જેમાં ટેકનોલોજીકલ એડવાન્સીસને કારણે 24 અવર્સનું હોસ્પિટલાઇઝેશન જરૂરી નથી અને ક્લેમ મળી શકે છે, પણ વીમા કંપની આપતી નથી. તો એવા સંજોગોમાં અમે બહુ વર્ષો પહેલા મને યાદ છે કે વીર નર્મદ દક્ષિણ ગુજરાત યુનિવર્સિટીમાં અમર અબાની કરીને પ્રોફેસર હતા અને તે જમાનામાં તો કે 8-10 હજારમાં ડેન્ટલ રૂટ કેનાલ થતી હતી. એ મારી પાસે આવ્યા. પહેલા તો મેં ના પણ પાડી કે હવે આ નાની રકમ માટે શું કામ કરો છો, પણ એમણે ઇન્સિસ્ટ કર્યું કે નહીં, આપણો રાઈટ છે ને આપણે કરવો જ જોઈએ. તો અમે કેસ કર્યો અને એ કદાચ ગુજરાતનો કદાચ 25 વર્ષ પહેલા મેં કેસ કર્યો. એ ફર્સ્ટ કેસ હતો રૂટ કેનાલ ટ્રીટમેન્ટમાં ક્લેમ પેએબલ છે. એવા પછી રૂટ કેનાલ ટ્રીટમેન્ટના અમે ઘણા બધા કેસો જીત્યા. સ્ટેટ કમિશને પણ એને કન્ફર્મ કર્યા ફોરમના જજમેન્ટમાં, પણ છતાં પણ આજે રૂટ કેનાલ ટ્રીટમેન્ટના ક્લેમો કે ડેન્ટલ સર્જરીના ક્લેમો વીમા કંપનીઓ રિજેક્ટ કરવાનું ચાલુ જ રાખેલું છે. એવા જ બીજા આંખના ઇન્ટ્રાવિટ્રિયલ ઇન્જેક્શનને લગતા કેસો હોય છે. મારી મધરને પણ આંખની તકલીફ થયેલી રેટિનાની, અને એમણે ડાયરેક્ટ આંખમાં ઇન્ટ્રાવિટ્રિયલ ઇન્જેક્શન લેવા પડેલા. અમદાવાદના ડોક્ટર મનીષ નાગપાલ પાસે લીધેલા અને મારા મધર તે વખતે ગુજરાતના કદાચ સેકન્ડ પેશન્ટ હતા જેના પર આ ઇન્જેક્શનનો પ્રયોગ થયેલો અને એનાથી એમને સારું થઈ ગયું. અને ખૂબીની વાત તો એ છે કે વીમા કંપનીએ મારા મધરનો ક્લેમ તરત ચૂકવી આપ્યો, પણ ત્યાર પછી આવા બધા ઘણા બધા કેસો થયા. તે બધા કોઈ પણ કેસમાં ઇન્ટ્રાવિટ્રિયલ ઇન્જેક્શન જે આંખમાં અપાય તેના કોઈ કેસ ક્લેમ ચૂકવ્યા નહીં. અમે ઘણા બધા કેસો લડવા પડ્યા અને મને યાદ છે કે અત્યાર સુધીમાં કદાચ હું 50-60 કેસ લડી ચૂક્યો છું ઇન્ટ્રાવિટ્રિયલ ઇન્જેક્શનના આંખમાં જે અપાય છે. તે સ્ટેટ કમિશને પણ કન્ફર્મ થયા છે. એક કેસ નેશનલમાં ગયો, નેશનલે પણ કન્ફર્મ કર્યો છે. પણ આજે પણ છતાં વીમા કંપનીઓ એવા ક્લેમો નામંજૂર કરવાનું ચાલુ જ રાખે છે. બીજો એક પ્રકારનો કેસ છે કે બેરિયાટિક સર્જરી. એને એ લોકો પહેલા કોસ્મેટિક સર્જરી ગણતા હતા, પણ બેરિયાટિક સર્જરી એ કોસ્મેટિક સર્જરી નથી. જો બેરિયાટિક સર્જરી જો બોડી માસ ઇન્ડેક્સ 40થી વધારે હોય તો એને બેરિયાટિક સર્જરી કરાવી એને માટે બહુ જરૂરી બને છે. અને ન કરાવવામાં આવે તો બીજા ઘણા બધા કોમ્પ્લિકેશનો થાય છે. એટલે જો ડૉક્ટર એડવાઇસ કરે તો એણે બેરિયાટિક સર્જરી કરાવવી પડે. તે કરાવે તો પણ એના ક્લેમો વીમા કંપનીઓ આપતી નથી. અને આ રીતે લિટિગેશનો થયા કરે છે. મને તો હું જ્યારે આવા પ્લેટફોર્મ પર કહેવાનો મોકો મળે છે ત્યારે હું વીમા કંપનીઓને હાર્દિક અપીલ કરું છું, મારા પ્રોફેશનલ હિતની વિરુદ્ધમાં જઈને અપીલ કરું છું કે જ્યારે કે ક્લેમો તમારી પાસે આવે છે ત્યારે જે ક્લેમો આવી રીતે સેટલડ થઈ ગયા છે, અગાઉ આપી ચૂક્યા છે, નેશનલ કમિશન કે સ્ટેટ કમિશને પણ અપાવેલા છે, એવા ક્લેમો તમારે આપી દેવા જોઈએ. એમાં લડવાનું બાકી રાખવું જોઈએ નહીં. પણ ખબર નહીં, પણ એ આ જાતના પ્રોસિજરો ચાલુ જ છે. બીજું કે જ્યારે 2 વિદ્વાન ન્યાયમૂર્તિઓ છે આપણી સાથે, સુકુમાર પટ જોશી સાહેબ જેવા પણ છે, તો આઈ વુડ મેક રિક્વેસ્ટ કે પટ જોશી સાહેબને પણ કે આપણે અહીંયા જે ક્લેમમાં જે કોસ્ટ આપે છે, ઇન્ટરેસ્ટ આપે છે, 6% ઇન્ટરેસ્ટ, 7% ઇન્ટરેસ્ટ, કેસ લડવાનો ખર્ચો 2000 રૂપિયા. આજે 2000 રૂપિયામાં કયો કેસ લડાય છે? 2000 રૂપિયા તો ઝેરોક્સનો ને ટાઈપિંગનો ખર્ચો થઈ જતો હોય છે. હવે આવા એટલા ઓછી રકમના વળતરો, ઓછી રકમના વ્યાજ, ઓછી રકમના કોસ્ટ એવું આપવાથી પેલો બિલ્ડરોને એ લોકો તો એમ કહે છે કે ગ્રાહકોને કે કઈ નહીં તું લડી લે, નહીં હું તને 6% વ્યાજ સાથે 2 વર્ષ પછી પૈસા આપીશ, વાંધો નહીં, હમણાં તું લડ, પછી આપણે અમદાવાદ કે દિલ્હીમાં મળી જશું, ત્યાં હું તને આપીશ પૈસા. આવી રીતે કહે છે. એટલે હું એવું માનું છું કે કોર્ટોની પાસે તાકાત છે, કોર્ટોની પાસે પાવર છે, તો કોર્ટોએ સખત એવા શિક્ષાત્મક વળતરની જોગવાઈ છે તો શિક્ષાત્મક વળતરો કરવા જોઈએ કે સમાજમાં એવો દાખલો બેસે કે બીજી વાર એવો માણસ હવે કોઈ ફરીથી આમ ન કરે. નહીં તો આ જે છે તે વહી રફતાર ચાલુ રહેગી કે ક્લેમ રિજેક્શન સેમ ક્લેમ રિજેક્શનો ચાલુ રહેશે, સેમ કેસો લડાતા રહેશે, પણ એમાં કોઈ સિચ્યુએશનમાં ઇમ્પ્રુવમેન્ટ થશે નહીં. એટલે કોર્ટોએ વધારે સ્ટ્રિક્ટ બનવું જોઈએ એવી પણ મારી એક અપીલ છે. અને આ જે બધા કન્ઝ્યુમર પ્રોટેક્શન એક્ટના જે જોગવાઈઓ છે એમની ચર્ચાઓ તો 3 મહાનુભાવો કરી ગયા છે. सुकुमार जोशी मैं उनको हरती फरती मीन्स के मूविंग यूनिवर्सिटी मानता हूँ कि उनको पूरा एक्ट मुंह पर ही है. जब वो आर्ग्यूमेंट भी करते हैं, मैंने सुना, मैं बहुत बार नेशनल कमीशन में गया, वहाँ उनको सुना, कोर्ट भी उनको ध्यान से सुनती है, दूसरे एडवोकेट भी ध्यान से सुनती है, और वो हमेशा एक रिस्पेक्ट वहाँ कैरी करते हैं. तो आज वी आर लकी कि हम ये पटेल साहब, परीख साहब और सुकुमार पट जोशी तीनों को हमें एक साथ में हमें मौका मिला कि हम આપણે બધા ત્રણેયને સાંભળી શક્યા અને એમની પાસે ઘણું બધું શીખી શક્યા. મને આ પ્રોગ્રામનો આયોજન કરવામાં મૂળ તો આઈડિયા મારો હતો અને મેં એમને પ્રિન્સિપલ ઇરમલાબેનને કહું, અને ઇરમલાબેન હંમેશા એટલા ઉત્સાહી હોય છે, કંઈ પણ સારો પ્રોજેક્ટ એમને કહીએ તો એ હંમેશા એના માટે રેડી હોય છે. તો એમણે તરત આ વાત ઉપાડી લીધી અને આ રીતે એમણે એક આયોજન કર્યું અને આ બધા વક્તાઓએ અહીંયા આવ્યા મહાનુભાવો અમારા આમંત્રણને માન આપીને હું એમનો પણ આભાર માનું છું અને મને આ જે તક મળી મને સાંભળ્યો એના માટે પણ આભાર માનું છું. થેન્ક યુ ઓલ.
Thank you, sir. Anisha ma'am. Shall I take over, Anisha ma'am?
Yes, ma'am.
Okay, propose the vote of thanks.
Yes, ma'am. Thank you, sir. I would like to call Anita ma'am to propose vote of thanks.
કમલેશ પટેલ સર ને અમદાવાદ જવાનું થયું અચાનક, સો એ સોમવારે આપણા સમક્ષ પાછા જોઈન કરશે, એટલે આપણે થોડું લંચ માટે વહેલા બ્રેક થઈશું આજે.
Good afternoon, everyone. I am honored and lucky to have the opportunity to give a vote of thanks on this special occasion. Feeling thankfulness and not expressing it is like wrapping a present and not giving it. On behalf of VT Choksi Sarvajanik Law College, I express my heartfelt thanks to our chief guest, Honorable Justice Sri Mahendra Parikh sir. Sir, indeed your words have inspired us. We are grateful to Honorable Justice Sri Vishnu Prakash Patel sir for sharing his graceful words with us. I wish to express my gratitude to Sri Rajesh Desai sir, Professor Sri Percy sir for inspiring by their words. I like to express our sincere thanks to Advocate Sri Sukumar Pattijoshi sir for giving an excellent coverage on consumer rights. I would like to thank our respected chairman of Administrative Committee, Advocate Sri Shreyas Desai sir, who graced us with his presence and guidance. Thank you, sir, for sharing with us your words of wisdom. I would like to thank all the respected representatives who have blessed us with their presence. We have been fortunate to be assisted by our principal in charge, Dr. Nirmala Dayal ma'am. You have been a constant support and given us a lot of encouragement. Thank you, ma'am. A special thanks to conference convener, Ms. Anisa Sahuala, for planning, organizing, and executing this virtual conference. Thank you, madam. I would like to thank all organizing team, teachers, and staff members. Last but not the least, I thank all students for showing their interest in the program and making this program a huge success. Thank you all of you once again.
Thank you all of you. શ્રેયસભાઈ, આપણે ટેકનિકલ સેશન લંચ પછી 1:30 વાગે, અને પટેલ સાહેબ, પરીખ સાહેબ, આખા ફંક્શનમાં તમે હાજર રહ્યા. પટજોશી સાહેબ, થેન્ક યુ so very much. We break for lunch.
Thank you, everyone. We will now have a recess break and shall commence the technical session at 1:30 p.m.
અરે શું આવ્યું છે? શું આવ્યું છે?
લસણ નાખવાનું છે, કુટી બનાવવાનું છે, લીલી ડુંગળી આવી છે, ગ્રેના.
Kindly end the meeting, all of you. Anisha madam, end the meeting for a while.
Yes, ma'am.
આખી બેઠી ગઈ હું આટલા ચલાવ્યું.
Anisha ma'am, can we formally end the meeting for a while? We again re-log in at 1:30. Anisha madam. Vikram sir is joining us in some time. Vikram sir has joined. Good afternoon, sir. Unmute karo. Sahib, unmute karo. So we can't hear you. Anisha madam.
Are you hearing me?
Yes, I can hear you. Good afternoon, sir is joining us in some time.
Very good afternoon. Happy to see you.
Good afternoon, sir.
Good afternoon to all of you.
Unmute karo.
So how was the first session?
Very informative. Anyway, Hina madam ने शहनाज बेन feedback आप लोग पोते बोलो के उलागे हिना में शहनाज बेन.
Yes, very informative, but indeed missed you and your expert talk.
So we can't hear you.
You will get very happy.
Anisha
Now
madam.
are you hearing me?
Yeah, Hina madam. Yes, I can hear you. Good afternoon, sir is joining us in some time.
Very good afternoon. Happy to see you.
Good afternoon, sir.
Good afternoon to all of you.
Unmute karo.
So how was the first session?
हिना मैम जोर के बोलो informative. Anyway, हिना मैडम ने शहनाज बेन feedback आप लोग पोते बोलो के उलागे हिना में शहनाज बेन.
Yes, very informative, but indeed missed you and your expert talk.
So we can't hear you.
You will get very happy.
Anisha
Now are
madam.
you hearing me? Who is going to
Yes, I
start?
can hear you. Good afternoon, sir is joining us in some time.
Very good afternoon. Happy to see you.
Good afternoon, sir.
Good afternoon to all of you.
Also there. Unmute karo. Just a minute. Just.
So how was the first session?
हिना मैम जोर से बोलो informative. Anyway, हिना मैडम ने शहनाज बेन feedback आप लोग पोते बोलो के फोन करूँ मने एक
Yes, very informative, but indeed missed you and your expert talk.
So we can't hear you.
You will get very happy.
Anisha
Now are
madam.
you hearing me? Who is going to
Yes, I
start?
can hear you. Good afternoon, sir is joining us in some time.
Very good afternoon. Happy to see
Good
you.
afternoon, sir.
Good afternoon to all of you.
Also there. Unmute karo. Just a minute. Just.
So how was the first session?
हिना मैम जोर से बोलो informative. Anyway, हिना मैडम ने शहनाज बेन feedback आप लोग पोते बोलो के फोन करूँ मने एक
Yes, very informative, but indeed missed you and your expert talk.
So we can't hear you.
You will get very happy.
Anisha
Now are you hearing me? Who is going to start?
Before we commence this technical session, I would like to inform all the participants that each author gets 7 minutes to present his or her paper. I request all the participants to please mind this time. Thank you. The first paper presentation is from Dr. Sharna Yudhimya Madam. The title of the book is E-commerce and Consumer Protection, Analyzing the Legal System. Over to you, madam.
Thank you. A very good afternoon.
Thank you, sir. Before we commence this technical session, I would like to inform all the participants that each author gets 7 minutes to present his or her paper. I request all the participants to thank you.
I would like to
The
share
first paper presentation is Dr. Sharna Yudhimya Madam. The title of the book is E-commerce and Consumer Protection, Analyzing the Legal System. Over to you, madam.
Thank you. A very good afternoon.
Thank you, sir. Before we commence this technical session, I would like to inform all the participants that each author gets 7 minutes to present his or her paper. I request all the participants in Germany. Yes, ma'am. Thank you.
I would like to share
First paper presentation is Dr. Sharna.
So my topic today is e-commerce and consumer protection, analyzing the legal regulations. I myself, Dr. Sharna Moria, Principal in charge, DD Law College, North. A very good afternoon.
Thank you,
I
sir.
would like to start my presentation.
Before we commence this technical session, I would like
Our
to inform all the participants
Mahatma
that
Gandhi,
each author gets 7
who has rightly said that the consumer
all the
knows
participants
in Japan.
Yes, ma'am.
In our food. I would like to share the So my topic today is e-commerce and consumer protection, analyzing the legal regulations. I myself, Dr. Sharna, Principal in charge, DD Law College.
Thank you,
I would
sir.
like to start my presentation.
Before we commence this technical session, I would like to inform all the participants
Group, can I
the consumer
Okay.
yes, ma'am.
Okay.
So we my topic is the importance of consumer protection or a consumer in the eyes of Mahatma Gandhi, Dr. Sharna, who will narrate with the initiation of ICT. We are all well versed in this term, that is ICT, Information and Communication Technology. Various fields of our life has widely occurred. Especially talking about consumer protection and consumerism. Selling and buying of goods and services is not an exemption. E-commerce is developed in the eyes of technology, electronic data industry, and electronic financiation. Because in a commerce there is a skill and there is getting very high. So with the help of internet now, it has developed various pieces of technology enabled consumer, especially EFT, that is electronic fund transfer, electronic exchange, the transfer of funds from one account to another. Either a single financial institution, electronic, or across multiple institutions, electronic financiation. Because in a commercialization, with the use of internet, various enhanced for the various commercial activities enabled a consumer a commercial activity electronic media, the arena of internet, electronic exchange. Now, if we from one definition of either e-commerce can be defined as buying or multiple products or services over electronic systems. The commercialization with the electronic commerce across various technology as electronic fund transfer, supply chain management, internet marketing, electronic data exchange, inventory management, automated data collection. Now, if we from one definition, the e-commerce business can be unique features, with its unique features, serves the benefits to the humankind in the commercial and business commerce. Hence, e-commerce transactions with the aid of internet allows consumer and entrepreneurs to conclude contracts for the exchange of goods and services automated with no physical boundary. That is the charm of e-commerce. There is no physical boundary and there is a user transaction goods, services, as well as the funds, the commercial, no doubt. These features are supporting many global standards or global internet. But at the same time, there are some limitations too. On one hand, e-commerce has a number of rewards in the form of low cost, economy, higher margins, better customer service, no physical quick and competitive transaction, knowledge market services, as well as other commerce has introduced some challenges which are too in the form of information sharing, threats to data privacy, security, and data some lack of quality. On one hand, e-commerce is a violation of consumer rights, higher margins, while there are various challenges in the conduct of e-commerce and the consumer protection knowledge e-commerce transaction is other customers has introduced some challenges. This is true. The issue of consumer protection is not properly addressed with the adequate mechanism that may adversely affect the child and the free flow of fruitful violation of market rights, and there are chances that it may lead while there are various challenges perception of consumer with respect to consumer e-commerce strategy. Hence, in this paper, we have preferred to examine and analyze this interface between consumer protection and e-commerce with the legal adequate mechanism that looking here and having a brief idea about e-commerce and consumer protection violation. One can say that information and communication technology will fundamentally change the way the business are mapped by citizens, including business houses and consumering. In this paper, yes, e-commerce has changed our mentality. How shopping used to be in a relative and how now we do online shopping and online purchasing at the tip of button. Look very quick and very convenient and very effective. Technology has innovated business transaction and communication with the appearance of e-commerce change. In the present scenario, business computer and e-commerce by the use of internet and new heights. Yes, transaction has changed our mentality. Yes, now already the world was a global village. Now you see e-commerce. The commerce system also has turned into global platform and now has e-commerce. Even access or we can even purchase things which are internationally available and we can access them worldwide. The glory and charm of e-computer impact of new technology advances and massive convergence of e-commerce transactions have caused attention of individuals. Already the world was business enterprise, governments and international commerce system also not as only global values and business endeavor, but also posing a variety of challenges in various segments of social and individual interests like data protection, consumer protection, privacy violations. As every coin has two sides, every technology has its pros and cons. Looking to e-commerce has a right number of benefits and advantages, but it does has a effect, or it does has an effect. Information disclosure of contract terms, their enforceability, failure to perform, lateness, that it might be pertaining to payment or transaction conformity or fraud or deception, unsafe products, confidentiality of information which the consumer provide, there may be chances it get hacked, identity of the seller, we don't know who is selling this product and who is beyond the computer line. effective grievance system and legal remediation disclosure, if anything goes contract terms, protection from the ill effect of high competition, failure to perform, which may include selling might be pertaining to payment, transaction conformity, there are chances or fraud or deception, unsafe products, goods delivered, confidentiality of information, which sometimes happen. We order something, there may be chances, and the quality of material, identity of the seller. We don't know who is selling this product or which is displayed beyond the computer line. Delivery effective grievance system and legal remediation disclosure, payment contract terms, protection from the ill effect of high competition, failure to perform, which may include selling might be pertaining to payment, transaction conformity, there are chances or fraud or deception, unsafe products, goods delivered, confidentiality of information, which sometimes happen. Why orders, there may be chances the quality of material, identity of the seller. We don't know which product or which is displayed beyond the computer line. Delivery effective grievance protection and legal remediation disclosure, payment contract terms, protection from the ill effect of high competition, failure to perform, which may selling might be pertaining to payment, transaction, there are chances or fraud or deception, unsafe products, goods delivered, confidentiality of information, which sometimes happen. Why orders, there may be chances the quality of material, identity of the seller. We don't know which product or which is displayed beyond the computer line. Delivery effective grievance protection and legal remediation disclosure, payment contract terms, protection from the ill effect of high competition, failure to perform, which may selling might be pertaining to payment, transaction, there are chances or fraud or deception, unsafe products, goods delivered, confidentiality of information, which sometimes happen. Why orders, there may be chances the quality of material, identity of the seller. We don't know which product or which is displayed beyond the computer line. Delivery effective grievance protection and legal remediation disclosure, payment contract terms, protection from the ill effect of high competition, failure to perform, which may selling might be pertaining to payment, transaction, there are chances or fraud or deception, unsafe products, goods delivered, confidentiality of information, which sometimes happen. Why orders, there may be chances the quality of material, identity of the seller. We don't know which product or which is displayed beyond the computer line. Delivery effective grievance protection and legal remediation disclosure, payment contract terms, protection from the ill effect of high competition, failure to perform, which may selling might be pertaining to payment, transaction, there are chances or fraud or deception, unsafe products, goods delivered, confidentiality of information, which sometimes happen. Why orders, there may be chances the quality of material, identity of the seller. We don't know which product or which is displayed beyond the computer line. Delivery effective grievance protection and legal remediation disclosure, payment contract terms, protection from the ill effect of high competition, failure to perform, which may selling might be pertaining to payment, transaction, there are chances or fraud or
unprecedented pace. Now, obviously, with this, great e-commerce expansion, this has led to an increase in the volume and consumer base for consumer markets, and therefore there must be corresponding legislative framework, which must effectively regulate its functioning and offer remedial measures to address grievances of consumers. And therefore there must be a humble attempt has been made, which must analyze these challenges in the light of the net consumer protection act of 2009 to address grievances of consumer protection e-commerce policy of 2010 has been made, which must now live in a world where it is the life of economic status or age of the consumers who are participating in the online market. So right from the age of 18, we now live in a world anybody is online, either by watching movies or shopping from Amazon. So right from the age of series on Netflix or booking taxis by Ola and Uber, making hotel reservations by watching movies or learning through new apps like Byju's and Byte Studio or making now the downside or learning through some new apps like Byju's and Byte Studio new forms of unfair pay tax. As one of our key speakers in the morning session had rightly pointed that unlike in the festival market, consumers get opportunity to examine goods. No such option is available online. In the retail market, there is free entry. Unlike in the point and come out to shop anytime you want. But when it comes to online, consumers are first in a maze. In the retail market, they ask for free entry and have to go and they ask for anytime you want. And when it comes to when you want it, consumers are first. Is basically decided on the value of consideration paid and not on the goods and services, not on the value of goods and services. is basically decided on the value of consideration, the consumer protection, and not on the e-commerce rules, not on the value of notified under the Consumer Protection Act 2019 on 23rd July 2020. So it's very decided on the value of rules that have brought consumer protection and not on the e-commerce rules, not on the value of notified under the Consumer Protection Act 2019 on 23rd July 2020. So it's very decided on the value of rules that have brought consumer protection and not on the e-commerce rules, not on the value of notified under the Consumer Protection Act 2019 on 23rd July 2020. So it's very decided on the value of rules that have brought consumer protection and not on the e-commerce rules, not on the value of notified under the Consumer Protection Act 2019 on 23rd July 2020. So it's very decided on the value of rules that have brought consumer protection and not on the e-commerce rules, not on the value of notified under the Consumer Protection Act 2019 on 23rd July 2020. So it's very decided on the value of rules that have brought consumer protection and not on the e-commerce rules, not on the value of notified under the Consumer Protection Act 2019 on 23rd July 2020. So it's very decided on the value of rules that have brought consumer protection and not on the more proactive. For instance, like if you see, for example, if you see the SEBI complaints redressal system, shortly also known as SCORES platform,
Nice, Tasneem.
Thank you, madam.
અનિશા મેડમ જસ્ટ અ મિનિટ.
Yes, ma'am.
હિના મેડમ અને કેતનાબેન 7 મિનિટનો સમય આપો.
Is there anyone left out?
હા સર છે
From
પણ
presenting
7 મિનિટ જ બોલવા દો. બધા બહુ છે 7 મિનિટ
Okay.
જ બોલવા દો.
તે જ ને હા. Is there anyone left out?
હા સર છે
From
પણ 7
presenting
મિનિટ જ બોલવા દો. બધા બહુ છે 7
Okay.
મિનિટ જ બોલવા દો.
તે જ ને હા.
અનિશા મેમ.
Yes, ma'am. Our next paper presenter is Miss Monica Brahmabhat. Her title of the paper is Rights versus Duties, Consumer Jurisprudence. Monica, ma'am. Our next paper presenter is Miss Monica Brahmabhat.
Am I audible?
Her title of the paper
Hello, everyone.
Yeah.
Am I
You are
audible? Okay, yeah, fine.
Monica, ma'am.
Good afternoon to all dignitaries. I'm going to present my topic, that is rights and duties, a consumer jurisprudence. Good afternoon to all dignitaries. I'm going to present my topic, that Rights and Duties, a Consumer Jurisprudence. Is my screen is visible?
Yes, ma'am.
Yes, ma'am. Yes.
Okay, ma'am. Thank you so much. Yeah. I know I'm actually talking about the rights of consumers. The Manusmriti. Now, Manusmriti is more authoritative because it provides an emphasis on ethical trade practices on that time period, and even though there are certain punishment provisions which was actually available to unfair consumers. So that means if in that time period when the Manusmriti was there, when the King Manu was there, and if someone was unfair to the consumers, there are certain provisions regarding the punishment to that people, even though there are certain provisions regarding alteration in any kind of a food, even though they had also mentioned the code of conduct, they had also mentioned the provisions regarding mixing of goods or in commodities, and due to that mixture, if that results into impurity, that will be an issue to the consumers. So this kind of a provisions which we have already in our ancient texts. The another important ancient text, that is Kautilya's Arthashastra, as it is name is given Arthashastra, we are actually focusing on the consumers and the trade practices and business practices. So they are talking about the best business practices when the people or the business or the traders or suppliers is giving best to the consumers. So when the consumer is demanding the thing which should be provided to him, which is necessary for him, so whatever is actually needy to the consumer, only that thing should be provided in that better performance. This concept was enlarged by the Kautilya's Arthashastra by Chanakya in this text. Now I'll move ahead. In constitutional provisions, we have certain constitutional provisions which are directly related to the consumer protection. In that Article 48, it says equal protection of law and equality before the law. Article 19, sub Article 1, and Article 8 is providing freedom of speech and expression, and that highlights right to receive information in consumer protection scenario. Article 21 scope is very wide, in which consumer protection is already covered. While we are talking about Article 32 and 26, under which mass consumers can ask for their rights to the judiciary through this article. Article 38, sub Article 1, and Article 39A is providing directive principles of state policy which are directly attracting consumers' protection. Now I am going to talk about salient features of the Consumer Protection Act 2019. Even though our older legislation, Consumer Protection Act 1986, was changed, but still, rights of consumers are remain the same in the newer legislation, that is Consumer Protection Act 2019. A consumer has a right of protection, information, assured, heard, redressal, and awareness. Even though in this new legislation, the unfair contract term is also introduced first time, which was not in the older legislation. The new legislation also established the Central Consumer Protection Authority, though it had many gray areas because they haven't tell us about the qualifications and the appointment of a member, that who will head this authority and how they will function. That is not clear. Certain provisions regarding penalties for misleading and false advertisement are also enrolled in this new legislation. This new legislation is focusing more on product liability, no doubt. The older legislation is also talking about the product liability, but here in the global e-commerce era, product liability is considered very important, and the complete justice is given in this new legislation to this point. And another features are like pecuniary jurisdictions are altered, provisions of mediation are also introduced, consumer can file e-complaint, and even though the definition of consumer is more generalized in this new legislation. Now, I would like to focus on the duty. Up to this, we were talking about the right of a consumer, but now I want to highlight some area of jurisprudence where those authors are telling about the correlation between rights and duties. If we will see the prominent author named Salman, he identified that a duty is considered as a roughly speaking act which one ought to do and acts opposite of which would be wrong. So, even though the another prominent author Gray, he also defined as duty as the acts or forbearance which an organized society commands in order to protect legal rights or legal duties of the persons to whom those commands are directed. And if Hebert is telling that duty does not mean the act or forbearance which the law commands, for these are objects of the duty. So that means one another prominent author named Austin, he classified the duties in four criteria. The first criteria, that is self-regarding duty. Second criteria is duty to indeterminate persons or to the public. Third one is a duty to one, not a human being, and duty to the sovereign or state. So I would like to highlight the first one criteria, that is self-regarding duties. That means when a consumer is buying something or availing something kind of services, some kind of a self-regarding duties is already obliged on him. So if I am buying something, there should be some kind of obligation on my side, because I will not fulfill an obligation, then I cannot realize the right in a perfect manner. Jurisprudence also tells us about there are three kinds of duties. First is positive and negative duties, primary and secondary duties, and absolute and relative duties. Whatever duties which are actually obliged on the consumer, they are came within the criteria for relative duties. Because relative, when there is a breach of relative duty, it is considered as a civil injury, and for that a consumer can get a compensation or can get a reinstatement for that particular loss from the judiciary. Generally, after observing the legislation of Consumer Protection Act 2019, I find out some of the duties which generally consumer may not aware about that and going to assess his rights without fulfilling his obligations. The first is a consumer, if availing a free services, that means if he is not paying a compensation for that, he cannot file a complaint. If a consumer is buying something, there should be some kind of a caution on his side only. He cannot buy blindly and afterwards he cannot complain for that. Whatever complaints which is consumer is making, that must be a genuine complaints. Consumer must be focused on quality, and consumer should not be attracted with false and misleading advertisement. While consumer is buying something, he must have access with the proper billing process through which he can assess the warranties and guarantees of the particular products or services. Consumers should aware about the risk of online shopping and online availment of banking and insurance services. When he is availing some kind of a risk which are actually hidden risk, he should be aware about that services. I have assessed some duties against rights. So that means if I want to avail the right to be heard as a consumer, that means I must have assessed the contact details of the consumer grievances handling system as a consumer. And if there is not any kind of a details are available, I should avail the purchase of that particular product or services. If as a consumer I want to avail right to safety, then as a consumer I must look and ask for standard quality of a product. I must check some kind of a standard quality marks which were provided for certain products, and I should not buy any kind of a spurious, fake, duplicate or hazardous products. As a consumer, if I want to assess right to redress, then my complaint should be as a genuine complaint. Even though there is a small loss, I can file a complaint as a consumer, because through this I can discourage the corrupt business practices. As a consumer, I should claim the penalties or compensation as provided in the rules and regulations to ensure that the quality delivery system improves. And I should study as a consumer all terms and conditions which is related to defection, refund, replacement or return as a warranty policies for my particular product or services. If consumer wants to avail right to consumer education or to be informed, then he must not be mislead himself through fake advertisement. He must assess relating feedbacks and market reviews for that particular product or services. And consumer must insist on getting complete information on the quality, quantity, utility, price of the product or services. According to this, he can decide that what is actually his need. And last one is right to choose. If the consumer wants to avail right to choose, they should go through all the alternatives which are available for his product or services with consideration conditions. And consumer should compare specifications, competition, and fair prices of the goods and services before finalizing the purchase of the product or services. I would like to conclude my presentation by telling that after COVID-19 era, I don't feel that literacy rate and consumer awareness is actually related, because in COVID-19 era, in this past 2 years, we learned many more things through online. Many more people who are doing his business only in cash transaction, they have already started their business with online transactions. So once if they have started their business with online transaction, that means all the duties which they had fulfilled. So first fulfilling their duties, first fulfilling their obligations, and then after they can assess their rights in a perfect manner. Because if the person, if the consumer is not availing or is not fulfilling his duties, and if he is going to avail his rights, that will be considered as an imperfect right and it will be not recognized by the law. Thank you everyone for listening me. That will be considered as an imperfect right and it will be not recognized.
Thank you, madam. Our next paper presenter is Ms. Silpi Burman. Her title of the paper is Critical Analysis of Deficiency in Services with Relevant Case Law. Silpi ma'am. Thank you, madam.
Yeah, ma'am.
Our next
Good
paper
afternoon,
presenter is
everyone.
Ms. Silpi
My
Burman.
topic is
Her
critical
title of the
analysis
paper
of
is
deficiency in
Critical
services
Analysis
with
of
relevant case
Deficiency in
laws.
Services with
So,
Relevant
coming to
Case
the
Law.
introduction part, many of us have encountered discrepancies with the amount, quality, or the features while purchasing any product. This is nothing but a deficiency of services. In our daily routine, we have faced this issue from buying groceries, booking flight tickets, to providing various different services. Everything consists of consumers and services. Many times there is an issue in the quality of the products and the services which amounts to dispute. Services which are not up to the mark leads to the dissatisfaction among customers. There is a cutthroat competition in the market. In order to survive, the traders indulge in various kinds of malpractices like overcharging, deficient supply of goods and services, unfair trade practices, defective goods, and so on. These factors have given rise to put consumer protection under active consideration, and it has to step to ensure the protection and welfare of the people. Consumer consciousness has begun to grow. This act enables a redressal of dispute arising out of the transactions between the consumers and goods or services providers. So basically, what the services means, so service is an intangible benefit availed by the consumer from the service provider. On a daily basis, we all human hire different services. Term service is defined under Section 2, subsection 42 of the Consumer Protection Act 2019, which includes facilities relating to banking, financing, insurance, telecom, processing, transport, etc. Service does not include any free services. It should be in a paid form. Like, for example, we can take legal consultation as a service where a lawyer is a service provider. Teaching is a service where the teacher is a service provider. Coming to the part deficiency. So, deficiency is defined under Section 2, subsection 11 of the Consumer Protection Act 2019. Deficiency is any sort of fault, imperfection, shortcoming, or defect in the feature, quality, amount, nature, authenticity, capacity, which is obligatory to be maintained and regulated as per the laws and the statutes in function, or any agreement or a contract claimed by the seller with respect to the products and goods, including any act of negligence, omission, or commission by the seller which causes loss to the consumer, which a prudent seller is supposed to do or is supposed to omit, but deliberately does the contrary, which actions amount to deficiency of services. So, for deficiency of services, we can take the example like inappropriate treatment done by a doctor leading to an increase in patient suffering. This is the deficiency in services. Or we can say that a customer buys a ticket for an AC bus, but the AC of the bus is not, it doesn't work out, which is a deficiency of the services. Coming to the objectives of my study, to study the key aspects of the deficient services. Second, to study the problems in services and its solution. Third, to analyze the benefits of the act in case of deficiency in services. Coming to my research problem, how Consumer Protection Act used the deficiency in services, how to decide compensation in the case of damages due to the deficiency in services, and third, how consumer protection helps to overcome the deficiency in the services. Coming to the conceptual background, the Act imposes strict liability on the manufacturer, distributor, suppliers, and the retailers for the causing injurious harm by its defective product or services. So, notwithstanding any contrary obligations and limitations of the liability, if a product or any of its components fail to comply with the necessary standards and therefore causing a defect in the product, shall make the manufacturer of the product directly liable for the damages under the Act or the common law of negligence. So, subsequently, the action can be brought for the injury, death, or any damage caused to a person or a property under the Act due to a defect of the product. This means that there is no need for the consumer to prove that the manufacturer was negligent for filing the suit against the manufacturer. The consumer also needs to prove that the defect in the product, damages, or the injury was caused to the consumer by the product or services only. Coming to the unfair trade practices we can see that the world is full of information technology only. Keeping the data is an easy task. So the company should use the best method to keep the data safely. If there is any deficiency in which leads to poor services, then the consumer can challenge for such deficiency in the form of like mental harassment or mental agony by the loss of the data. So in such case, the heavy compensation can be demanded from the person who is providing the services. Then the consumer complaint redressal mechanism. So a complaint consists of a written allegation for claiming liability against the manufacturer, the seller, the product, or the service provider. Such complaints can be filed by one consumer or more than one consumer, any registered voluntary consumer association, peers, or the legal representative of the consumer, the central or the state government. In the case of a minor, his or her parents or a guardian can file the complaint on behalf of the minor. So nowadays, a consumer complaint can be registered electronically. Complaint before the District of Consumer Forum, and furthermore, by a person in intimating the insurance company about the theft, this cannot be the ground to repudiate an insurance claim. Coming to the second case law of Amitabh Das Gupta versus United Bank of India in the year 2021. The case had gone into the appeal. The appellant's mother took a locker on the rent in the Deshapriya Park, Kolkata branch of the correspondent bank. So the appellant complaint was included as a joint holder in the of the locker. The appellant visited the respondent bank to operate the locker and deposit the locker rent. However, the appellant was informed that the bank had open his locker for non-payment of rent dues. Further, the locker had subsequently allocated to another customer, and when they opened it, and it was found that only two ornaments were found out of the one. So, however, the respondent bank contended that only those two ornaments were found. So it is a inventory prepared by the respondent. When the locker was broken upon in the presence of the independent witness, subsequently the appellant filed a consumer complaint before the district consumer forum, and furthermore the appeal was filed. The Supreme Court issued guidelines on allocating and operating of the lockers, and the court held that the bank be liable under the Consumer Protection Act for the deficiencies in the law.
I now request.
Anisha madam, please give only 6 minutes. There are lots of dignitaries joining us and lots of participants also. Only 6 minutes. And then you can remind them and 1 more minute extra.
Okay, ma'am. Okay.
Madam, please give only 6
I now
minutes,
request
huh?
Ms. Anita Jadhav. Her paper presentation title is Statutory Provision Dealing with Misleading Advertisement with. Okay, ma'am. Okay. I now request Ms. Anita Jadhav. Her paper presentation title is Statutory Provision Dealing with Misleading Advertisement. Statutory. Okay, ma'am. Okay. I now request Ms. Anita Jadhav. Her paper presentation title is Statutory Provision. Anita, ma'am. Statutory. Okay, ma'am. Okay. Okay. Her title is Statutory Provisions Dealing with Misleading Advertisement with Special Reference to the Consumer Protection Act 2019 and Analysis. Over to you, Anita, ma'am. Okay. Her title is Statutory Provisions Dealing with Misleading Advertisement with Special Reference to the Consumer Protection Act 2019 and Analysis. Over to you, Anita, ma'am. Okay. Her title is Statutory Provisions Dealing with Misleading Advertisement with Special Reference to the Consumer Protection Act 2019 and Analysis. Over to you, Anita, ma'am. Okay.
અનિતા બેન સ્ક્રીન શેર થઈ જશે તમે ઇન્ટ્રોડક્શન તો ચાલુ કરો. અનિતા બેન સ્ક્રીન શેર થઈ જશે તમે ઇન્ટ્રોડક્શન તો ચાલુ કરો. અનમ્યુટ યોરસેલ્ફ. અનિતા બેન અનમ્યુટ યોરસેલ્ફ. Unmute yourself.
Good afternoon, respected session set and all in one. Myself, Anita Jadhav, Assistant Professor, VT Choksi, Sarvajanik Law College. Topic for presentation is Statutory Provisions with Misleading Advertisement with Special Reference to the Consumer Protection Act 2019 and Analysis. Nowadays, people are living in an age of competition, and in order to sustain their business, they are somehow restoring to advertising. Advertising is used to convey any information related to product and services in the market. An advertisement is an announcement online or in a newspaper or televisions or in other way, like announcement like product, event, or any of the job. Sometimes manufacturers or producers are given like false information by advertisement, and then it becomes misleading advertisement. Consumer Protection Act 2019 gives so many provisions related to misleading, and there are mainly two objects which is concerned with my paper. First object is to get the meaning of false and misleading advertisement into the new Consumers Act New Consumer Protection Act 2019. Second object is to analyze provisions which concern misleading advertisement. There are mainly doctrinal research methodology is used by me, and like official websites, books, and e-library. Library are used for the preparation of this paper. There are mainly two research problems. First one is how provisions of Consumer Protection Act 2019 is used and helpful to the consumers. And second research problem is like how the Central Consumer Protection Authority is useful to the consumers. And like literature review, there are mainly two papers is used by me for the preparation of this paper. First paper is Dr. R.M. Kamble, Law Governing Advertisement in India. In this paper, researcher had given the brief meaning and provisions related to advertisement and misleading advertisement. Then second literature review is Dr. Madhvi Tripathi, a study on impact of false advertisement on the consumer buying behavior. From this board paper, I have got idea for this research topic, and there are some lacuna which is on that paper, briefly analyzing, which are analyzed contemporary and by me. There are mainly three issues which is concerned with misleading advertisement. Consumers are, I think PPT is visible. There are mainly three issues which is concerned. Yes.
It is visible. It is visible.
Yes, ma'am. And challenges which is faced by consumer. First issue is consumer are not aware about their rights and remedies which are provided by the Consumer Protection Act 2019. Second issue is in the era of information technology, consumers become directly or indirectly victim of a false and misleading advertisement. There is no time limit for speedy justice, as it is necessary to justice in specific time. Now, I will move on statutory provisions related to misleading advertisement in India. First, the Consumer Protection Act 2019, Section 2(1) said about meaning and definitions of advertisement. Then Section 228 gives definitions of misleading advertisement, and Central Consumer Protection Authority is most important part of the Consumer Protection Act 2019. Establishment of Central Consumer Protection Authority power to issue direction in respect of misleading advertisement is also given provision in the Consumer Protection Act 2019. And then commission and appeal related provisions are given in the Section 24 of the Consumer Protection Act 2019. Article 19 of the Constitutional Law of India is
Anita madam,
advertisement. Article 19(1)(a) is concerned with freedom of speech and expression, and 19(2) restriction on these provisions. And most important judgment which is also concerned with this Constitutional Law of India, Hamdard Dawakana judgment, as well as Tata related judgments, and UDHR provision, Article 3 it is given the provision related to freedom to the consumer. Then in UK, Consumer Credit Act 1974 as well as Competition Act 1998, all are connected with consumers' rights. Misleading advertisement and misleading omission related provisions covered under Consumer Protection from Unfair Trade Regulations 2008 CPRS, as well as Business Protection from Misleading Regulations 2008 BPRS is concerned with commercial practices. Then there are mainly now I will directly move on conclusion and suggestion. The Consumer Protection Act 2019 protect the rights of the consumer, but detailed provisions is also given in the Consumer Protection Act 2019. But awareness is required in society. Sometimes consumers have no idea about their rights. Government needs to spread awareness by programs, social media, etc. Consumer authority can provide proper way for how consumers can protect themselves against misleading advertisement. If the school provides basic education for the rights of the consumer, then the information can reach the students as well as their families. Technology is a necessity in today's world, but the government should give guidelines to control the misleading advertisement like it. Speedy justice and buyer beware are way for protection to the consumer rights which concern misleading advertisement. If we compare consumer rights related to related provision with UK laws, in India there is no special designed laws to deal with misleading advertisement. Thank you so much. Related provision with UK laws, in India there is no special designed laws to deal with misleading advertisement. Thank you so much.
Thank you, Anita ma'am. Now I'm calling Ushma ma'am for her paper. Her paper title is Critical Analysis of Provisions of the Mediation in the Consumer Protection Act 2019 and Consumer Protection's Mediation Rules and Regulations 2020. Over to you, Ushma ma'am.
Yes. ક્યાં છે મેલ હમણાં 11 વાગે જેવું કરેલું હા હું હવે હા યસ તો પીડીએફ
ઉષ્મા મેમ ખાલી 7 જ મિનિટ. હા ઉષ્મા મેમ ખાલી 7 મિનિટ.
હા એક મિનિટ તો હવે મેં એટલે જ કીધું તમે ચેક કરી દેજો.
ઉષ્મા મેમ ખાલી 7 જ મિનિટ. હા ઉષ્મા મેમ ખાલી 7 મિનિટ.
મેં 11 વાગે કરેલો હતો તો હું કરું મારા આમાં ડાઉનલોડ કરી દઉં.
ઉષ્મા Anisha ma'am, if there is a technical
just a minute. એક જ હું મેલમાં મેં પીપીટી ડાઉનલોડ કરી લઉં એક જ મિનિટ.
તો તમે વર્બલી ચાલુ કરો બેન, ત્યાં સુધી કોઈ બીજું તમારું પીપીટી હેલ્પ કરશે. યુ સ્ટાર્ટ વર્બલ પ્રેઝન્ટેશન. ઓકે, સેશન 2 નો ટાઈમ થઈ ગયો. યુ સ્ટાર્ટ વર્બલ. ઓકે, તમે વર્બલી ચાલુ કરો બેન, ત્યાં સુધી કોઈ બીજું તમારું પીપીટી હેલ્પ કરશે. યુ સ્ટાર્ટ
ઓડિયો બંધ કરો.
સેશન 2 નો ટાઈમ થઈ ગયો. યુ સ્ટાર્ટ વર્બલ.
ઓડિયો બંધ કરો.
ઓરલ સ્ટાર્ટ કરાવી દો ને. પીપીટી કોઈ બીજું શેર કરશે? ઉષ્મા મેડમ, many dignitaries are there with us today. They are getting late. ઓરલ સ્ટાર્ટ કરાવી દો ને. પીપીટી કોઈ બીજું શેર કરશે? ઉષ્મા મેડમ, many dignitaries are there with us today. They are getting late. ઓરલ સ્ટાર્ટ કરાવી દો ને. પીપીટી કોઈ બીજું શેર કરશે? ઉષ્મા મેડમ, many dignitaries are there with us today. They are getting late.
Good afternoon to all. Sorry for the inconvenience. I am just starting now with my PPT. My topic is good afternoon to all. Sorry for the inconvenience. I am just starting now. My topic is critical analysis of provisions of mediation in Consumer Protection Act 2019 and Consumer Protection Mediation Rules and Regulations 2020. The main purpose, I want to critically analyze basically these all provisions relating to mediation, and in order to ensure whether they are proper enough that can ensure speedy dispute resolution, because it is to be kept in mind that consumer dispute commissions are already not following procedural laws. They are just supposed to follow the principles of natural justice. So trial is already speedy in that system, and still there was huge backlog of cases, and that led to the need of introduction of concept of mediation even in the Consumer Dispute Redressal Commission. So it is to be analyzed the necessity of the provision, and if they are implemented properly, then how much it could help in the process of speedy dispute resolution. So, literature review, I have referred basically three major research papers of firstly that of Sheetal Kapoor, or Associate Professor and Convener of Consumer Club, Department of Commerce, Kamala Nehru College, University of Delhi. She wrote the paper when the Consumer Protection Bill 2019 was introduced, and so at that time these provisions were not implemented. So my research paper would cover that portion by doing doctoral as a non-doctoral research work on to analyze whether these provisions are implemented or not. And secondly, research article on consumer mediation in Consumer Protection 2019 by Dhwani Daftari. She has laid down very nicely the possible challenges that can come in implementing the provisions relating to mediation. And third article on India mediation resolution to complaints under the Consumer Protection Act 2019 available on the Mondeck website by Abhishek Bagga and Smita Paliwal. Objectives of the study are basically three: to analyze these provisions relating to mediation; secondly, to find out the ground realities regarding implementation of such provisions by conducting non-doctrinal survey amongst the lawyers handling consumer matters. And hence I have prepared also the Google form for that purpose to conduct that survey, e-survey from the lawyers, restricted to only Surat District Commission, and to ascertain future challenges in the implementation of these provisions. Now, I have already narrated the limitations and the methodology, doctrinal as well as non-doctrinal research methodologies adopted for writing this research paper. And now, moving on to the concept of mediation, I will just like to briefly put up the concept of mediation. Mediation, we all know, it is one of the alternative dispute resolution method, but in which the mediator will act just like a catalyst who does not take part in the chemical reaction. And just as the catalyst does not take part in chemical but speeds up the entire chemical reaction, mediator has to play just that role, or to create a platform wherein the parties can come to the speedy resolution. So what are the possible benefits of this mediation process? Less cost compared to the litigation, and the time taken would be reduced if the parties naturally, willingly and voluntarily participate, not half-heartedly.
Ushma, please,
Secondly,
Ushma ma'am.
Due to the feature of confidentiality, the parties more open up before the mediator than before the Consumer Commission or presiding president. This is another benefit. Third is increased control of the parties over resolution in comparison to the dispute resolution given by the Consumer Commission. On compliance can be ensured because here the parties themselves have decided and arose at particular settlement agreement. So bindingness can be ensured. So appeal, provisions of appeal, where the matter gets resolved at the lower level, but the appeal goes on. The dispute is not resolved, just the matter is disposed of. That can be checked. Expertise support is available, which resolves problems and not simply the case. Relationships are preserved, and success of mediation proceedings mainly depends upon the conviction and perception of the mediator, how he deals with the matter. That plays a vital role and could prove to be beneficial to the parties. And now I would quickly move on to the challenges and the conclusion suggestions. That plays a vital role and could prove to be beneficial to the parties. And now I would quickly move on to the challenges. Provisions relating to mediation are given in Chapter 5 of the Consumer Protection Act, and which are to be read with consumer protection mediation rules and regulations. According to the section 37, according to section 37 of this act, and the Consumer Commission, if find, it is just like the section 89 of CPC, wherein if the Consumer Commission finds the chances of settlement between the parties, they can refer to the mediation process, and mediation is to be completed within a time limit of 3 months. Once at the end of that 3 months, mediator is supposed to submit the report or the failure report, whatever may be the case. And this is the glimpse of that particular provision.
Madam, please. Sorry to interrupt. Please conclude.
Moving to the challenges, if we critically analyze, I'm just concluding within 2 minutes. Okay. Critical analysis of the fruitfulness of such provisions, if we see, the data is already available on the website of National Consumer Dispute Redressal Commission, which shows that at 5,54,925 cases are pending in total, out of which 74% are pending at the District Commission, 21% State Commission, 5% National Commission. This shows that there is huge backlog of cases at the first level of redressal itself. Hence, the provisions relating to mediation are necessary. Now, the point is how they are implemented. Now, so to study that, we will move on to the second part of analysis, that is by way of questionnaire among the lawyers. So I prepared the questionnaire containing the 5 questions: that awareness regarding the lawyers. Second, infrastructure is created of mediation at Surat District Commission. How many matters are referred to such mediation cell, and how much of the referred matters are solved by this mediation process. So lawyers, I would tell that there is no such mediation cell established till now at the Surat District Consumer Commission. So naturally, the second and third and fourth answer would come to the negative. Lawyer's opinion is that at times a mediation could stall the matter, delay the process entirely, because the process of consumer dispute is already 3 months. And if you refer to the matter to the mediation, at times a party consents to the mediation just to stall the matter. So this should be checked by on the part of commission. Now the challenge is naturally would be this. First, complaint. Generally, person files a complaint as a last resort after all chances of amicable settlement are failed. So this is to be thought whether mediation is really necessary.
Someone tell her
if it is necessary, then how it should
teachers chair.
And the time of 3 months is quite a big time period in the Consumer Commission matter.
Ushma, will you please conclude?
Just nature of mediation can prove to be a lacuna in settlement cases. Fourth, lack of judicial infrastructure as narrated above. Possibilities that the party autonomy is not taken care of when the mediation is imposed. And so suggestions are naturally this. The Act should set a cap on the type of cases. The Act is still not clear. Act just rules and regulations states only which cases can be referred to mediation. But which type of cases are still to be referred, there is no clarity in the Act that would clear the confusion. And again, there will be more backlog in the mediation process itself. So, alternative to the alternative will again be lead to the suggestion of certain more alternative. This cannot be the end of the entire situation. So, there should be some cap on the type of cases that can be referred to the mediation to avoid backlogging of cases referred to mediation. Secondly, on some other innovative ADR methods like online, there is a judicial consumer courts can go for the national consumer spread awareness regarding national consumer helpline with this number. There is a facility of online consumer mediation center at National Law School, Bengaluru, under the aegis of Consumer Affairs, Ministry of Government of India, that can online give the facility of solving the mediation to the consumers. So there should be online dispute resolution and online mediation cells, and awareness should be spread, and which should be approachable without filing the complaints. And they could directly approach these mediation cells and avail of the services of this online mediation cell, wherein they can get the service of the experts all over India. Awareness should be brought among the lawyers as well as the citizens regarding the necessity of this mediation to solve the matter speedily. Fifth, there is a need to create an ombudsman to keep a check that whether the mediator acts in a proper manner or not, and complaint can be filed if the mediator is not acting improperly. Thus, it should be noted that success of consumer mediation in India will purely depend upon the effectiveness of mediation cells and how effectively they would dispose of the complaints in a speedy manner. Thank you.
Ushma, we all are teachers and we cannot stop before but you have to stick to the timeline. Sorry, JT sir. Sorry, Vikram sir. We are trying to create.
Ma'am, you are not audible.
I am speaking.
Yeah, ma'am.
We are trying to create one more link for the third technical session as suggested by Harshad Bhai from Bharuch. Vikram sir, thank you. And Anisha ma'am, you kindly take over.
Okay, ma'am. Thank you, Dr. Vikram Desai sir, Dr. Hina Makwana ma'am, and Dr. Ketna madam for being part of this conference, and the participants for making this technical session valuable and insightful for all our attendees. I request all participants to please mind their time. For commencing the second technical session, I request Ms. Avni madam to continue the session. I request all participants to please mind their time. For commencing the second technical session, I request
Thank you very much, ma'am.
to continue the session. Thank you, Anisha ma'am. Now we commence the second technical sessions of our conference. The session chair for these technical sessions are Dr. Jyoti Desai sir, Dr. Alkesh Swami sir, and Dr. Jaydevi Rajguru ma'am. Dr. Jyoti Desai sir is the former Dean of the Law Faculty, VNSU. He has written and published several books and research papers on law, and under his guidance, many students have received their doctorate degrees. His expertise in research methodology has won him several accolades. He is a taskmaster who brings out the best in his students and at the same time is just and fair. He clearly is an asset to the law academia. Dr. Alkesh Swami sir is an assistant professor at Memiskil Law College, Bharuch. He is taskmaster who brings out the best in his student and at the same time is just and fair. He clearly is an asset to the law academia. Dr. Jaydevi Rajguru is an assistant professor at Siddharth Law College, Cambridge. She completed her PhD in human rights and international humanitarian law. With her distinguished knowledge in law, she is an asset of the law academia. Thank you, Dr. J.T. Desai sir, Dr. Alkesh Swami sir, and Dr. Jaydevi ma'am for making time for this conference, for being session chair for this conference session of the national conference. Before we commence the technical sessions, I would like to inform all the attendees that each author has 5 minutes to present his, her papers. I request all the participants to please mind their time. Thank you.
અલ્કેશ સર, જેટી સર, 6 મિનિટ એટલે તમે જ પ્લીઝ સ્ટોપ કરો. અમારી તો કોઈ વાત સાંભળતું નથી આજે. પ્લીઝ. And we are trying to create one more link.
Okay.
અલ્કેશ સર, જેટી સર, 6 મિનિટ.
Dr. Twinkle Desai.
Yes, ma'am.
Okay. Dr. Twinkle Desai is here. Her paper is Impact of Consumer Protections Act 2019 and its rules on e-commerce. Over to you, ma'am.
Thank you, ma'am. Warm afternoon to all of you. I'll just share my screen first and then I'll begin with my presentation. Warm afternoon to all of you. I'll just share my screen first and then I'll begin with my presentation. Is my screen visible?
Yeah.
Yes. Your screen is visible, ma'am.
Yes.
Good afternoon once again. So my topic for presentation today is Impact of Consumer Protection Act 2019 and its rules on e-commerce. Now, multiple rules have been framed by the central government. My paper is focusing specifically with regards to consumer protection e-commerce rules that were passed in July 2020. So before we understand the importance of e-commerce, let me just share with you some basic stats. So as of January 2022, as reported on Data Portal, 4.92 billion users of internet are there in the world. Out of this population, 3.78 billion users are using the internet for the purpose of purchasing goods or services online. Moving on to India. In India, 658 million users are there who are using internet, whereas out of that, 643.9 million users are using internet for the purpose of purchasing goods or services through an online mode. So this number very clearly shows the expanding scope of e-commerce within India. With the expansion of e-commerce, there is a need to address the various threats that have been posed in the e-commerce. And for this purpose, Initially, we did not have the Consumer Protection Act 2019. So the 1986 Act was interpreted by the judiciary in a very beneficial way, and thereby to specifically address the problem of e-commerce, we have the Consumer Protection Act 2019. So the act and the rules together give us a good platform through which we can protect the interest of the consumers on e-commerce. Before moving to the next portion, I would just like to point out the various e-commerce models that have been defined and classified within the e-commerce rules. The internet e-commerce entity, e-commerce entity is divided into two parts. That is inventory based e-commerce entity, where the purchaser directly sells the goods to the seller, the seller directly sells the goods to the purchaser. This is further classified into two parts: single brand e-commerce entity, where under single brand multiple goods are sold, and multi-brand e-commerce entity, where under various type of brands are kept and various type of goods are sold in the same. The IKEA, Nike, Adidas, these are some of the examples relating to single brand e-commerce entity, whereas multiple brands will be Big Bazaar, Reliance, or Shoppers Stop. Looking into the marketplace e-commerce entity, it just provides you a platform through which buyers and sellers can connect with each other. Such platforms are Tata Click, Amazon, and Flipkart. Now, coming to the protection of consumers, under the Consumer Protection Act 2019, the definition of advertisement has been expanded to include the advertisement through the medium of electronic media, internet, or website. Further, definition of consumer has been expanded, wherein the explanation states that if the goods are sold through the medium of direct selling or e-commerce, then the consumer will be protected under the present act. Unfair trade practice states that if one of the method of unfair trade practice is that misrepresentation by the seller. So if the misrepresentation is done by the means of electronic records, then also the consumer will be protected under the same. Coming to the online dispute redressal, complaints can directly be filed through online mode. This will simplify the method of filing the complaint, and for this purpose, the Consumer Commission online application portal called eDakhil.nic, that essential information should be very clearly stated and which is given in an understandable manner. Along with that, a grievance dispute redressal mechanism must be created, wherein a grievance officer must be appointed who will take note of the complaint within 48 hours, and the dispute must be resolved within the period of 1 month. Coming to the liabilities of marketplace e-commerce entity, they are required to exercise due diligence while performing their duties.
Time up. Twinkle ma'am, time up. Kindly conclude.
Yes, ma'am. Yes, ma'am. Yes, ma'am. The liabilities are specifically mentioned. Duties are also mentioned within the same. The challenges state that there is still, looking into the rules, the issue of data protection and data privacy is not sufficiently addressed. The issue of cross-border transactions with regards to jurisdiction is also not properly addressed, and the question of liability of marketplace entity, where there is a contradiction between IT Act regarding the safe harbor provision under section 79 and the liability of marketplace entity placed within the e-commerce e-commerce rules. There is a contradiction between the same which needs to be resolved. So in order to concluding my presentation, I would say that there are sufficient safeguards placed through the new act as well as the rules, but still some loopholes are there, which is expected to be addressed in the upcoming proposed amendments that the ministry is currently working on. moving to the recommendations, I would say that active monitoring on the online platform is required. Further, provisions relating to the compliance of the rules must also be specifically mentioned with regards to industry. Further, strict takedown policies are required where misrepresented, defective or deficient goods or services are reported, and they must be taken down immediately. More comprehensive terms and conditions must be introduced in order to properly safeguard the interests of consumers with specific regards to e-commerce transaction and the issue of privacy. Furthermore, an enabling environment must be created where it allows the development of trust and confidence between the buyers and sellers. So the laws are sufficient as of now, but there is still a lot of scope of improvement and further strengthen the
Twinkle madam,
interest
time
of the
over.
protection of the consumers. Yes, sir. I am about to conclude. These are just my references and which I have referred. And with this, I conclude my presentation.
Thank you, ma'am. Our next paper presenter is Dr. Sunny Hassani, sir. His paper title is Protection of Consumer in India with the Advent of E-Commerce. Dr. Sunny, sir. His paper title is Protection of Consumer in India.
Good afternoon, all of you. Am I audible?
Yes, sir.
Yes. Fine, thank you. Respected yes, respected principal of VT Law College, to all the participants, good afternoon to all of you. Dr. S. Hassani, and I will be presenting my. I hope my screen is visible, ma'am.
No, sir.
I hope my. Okay, it's great. I have already shared my, but I don't know why it's visible. Okay, anyways, we will be speaking on protection of consumers with the advent of e-commerce in India. As we all know, new consumers with the advent of Act 2020, that COPRA 2019, the legislation has come on our country, and we all are known with the technological development and especially the development in terms of online shopping. Nowadays we are all doing that. The old Act of Consumer Protection of 1986 was obviously not having any kind of provision relating to online shopping or e-commerce platforms, as we know that it was an Act of 1986, and at that time we were not having the facilities of internet and online platforms, and hence we were not able to put that provisions during that act. But much was debated, much was demanded from the legislature from right from year 2000, and finally, after making so many deliberations and constituting so many committees, expert committees, getting various people together, the new Act of Consumer Protection Act 2019 was passed. Friends, this act is having a speciality of, we can say that it has comprehensive coverage of provisions, including the misuse made by the sellers, or I can say the dealers, in regards of e-commerce platforms or e-consumers. Now, friends, I am not able to share the screen, but we can I can tell you that one of the presenter told that the district commission is having the jurisdiction to decide up to matters of 1 crore, but new rules have been laid down by the legislature. Now it's made up to 50 lakhs. So district forums shall make the matters heard if it is the value of up to services up to 50 lakhs rupees, so that overburdenness of the district commission was obviously pleaded when this new act came into the picture. So that problem is also been now solved or addressed by the government. Also, e-Dakhil portal has been started. Now a person can file online complaint. He can upload the documents online also. So this kind of provision is also given to in this new rules and regulation of Consumer Protection Act. Obviously, CCPA is there, and mediation is there. So many.
Your screen is not visible.
Obviously, CCPA is there. Okay, I have shared the screen, but it's not visible. Okay, I'll stop sharing. I'll go orally, no problem. So that is what I was saying, that new act has been legislated and e-Dakhal portal has been started as a part of Atmanirbhar Bharat. Government is trying to promote more and more products which are prepared or which are manufactured in India to be used by the people. So what government has did, they have made mandatory to online platforms to display the origin of the country to where the product has been produced or manufactured. So nowadays you can find on Flipkart or Amazon India, you can find easily that products country of origin also is mentioned. So these kind of restrictions, or I should say these kind of regulations, are being introduced by the government, and new rules have been laid down by the government to control the e-commerce, especially. More and more people are now attracted nowadays to really make their shopping, and they have, especially in the era of COVID, when everywhere there was a lockdown, this e-commerce platform got really good earnings as far as transactions are concerned. So that is why it was very necessary to have a good regulation on these kind of things. And so new notifications of rules is also been made, as I told you, and e-Dakhil portal is there. Then obviously the Consumer Protection Act, as it has declared the 3-tier quasi-judicial mechanism that you all know, and now we can say that this law seems to be a very really comprehensive law as far as e-commerce is concerned. I'm really sorry that I was not able to share the screen. Maybe I am having issue with my laptop, but anyhow, I would love this morning during my session, when I will be session chair in the next session. So probably at that time I may share my screen. So once again, thanking all the organizers, especially Dal Madam and all the respected session chair for giving me this opportunity to present my paper in front of you all. And I think that I am within the time. And again, to you all of you, we will be
So you're very much within time, but I have one request. We have created a parallel Zoom link. I have shared that with you. Kindly start your third session accessing that link. Everyone is waiting for you to join that session, which you are sharing. Okay?
Fine.
Thank you, Sunny.
Yeah.
Thank you, sir. Our next paper presenter is Ms. Bhavna Valvi. Her paper title is Consumer Protection and Constitutional Perspective. Bhavna, ma'am. Next paper presenter is Ms. Bhavna Valvi.
Yes, ma'am. Hello.
Title is Consumer Protection and Constitutional
Ma'am. Hello.
Yes,
Yes,
ma'am, you
whether
are
I am
audible.
audible. So, ma'am, can I share my paper or can I present verbally only?
Yes,
I have not
Ma'am,
made
it is-
PPT.
Okay, so no issue, ma'am. You can present orally.
Oh, okay. So my title is Consumer Protection and Constitutional Perspectives. So, consumer, as we see the definition of consumer, it extend a person who buys any commodity to consume either as eatable, otherwise from the shop, business, house, corporation, store, or a fair price shop, to a person who uses the private or public services. Consumer is a very old concept when human beings started living in groups and they started satisfying their needs through the barter system. Every member of the group became consumer. So the word consumer and the term consumer protection has been mentioned in, if we see our constitution, there is not such word is mentioned there, but we see the preamble of our constitution, it mentioned that we the people of India having solemnly resolved to constitute India. So the people of India itself complete the word citizens and consumer, as every one of us consume goods every day. So there are certain consumers perspectives relating to the constitutions in our preamble, fundamental right, directive principles of state policies. And it should be noted that justice is genes which the consumer is mentioned as a spices.
So the aim of consumer justice is to ensure that the consumer get what he has paid for in quality and in right measures, and to enforce his rights if he does not get the right thing in right measures for which he has paid of the value. So the concept of consumer justice also involves some kind of safeguards of these members of society from all sort of malpractices, exploitative deeds of market operatives and incidents. So having an equal bargaining positions wise as a manufacturer, trader, sellers, distributor, consumer need legal protection and to attain the substantial degrees of economic equality in the marketplace, which is the legitimate expectations and concept of social justice as device to attain the same. So under our constitution fundamental rights, as one of the participants have already mentioned that we have certain provisions relating to the consumer under article 14, 19 and 21. So under article 14, it deals with right to equality, and it is enforced about the quantity, quality, potency, standards and purity of price of products curricle to the exercise of other consumers' rights. Right to know, that is right to receive and impart information, which is given under article 19(1)(g), that is the freedom of speech and expressions. It deals that a citizen has a fundamental right to use the best means of imparting and receiving the information. So freedom to telecast, which is more expressly given in Doordarshan, has been recognized by the Apex Code in Doordarshan cases. Article 21 of Indian Constitution guarantees the proper life, private liberty, which incorporates sort of rights, attributes, which is also expressed in RP Limited versus India Express newspaper by Supreme Court. That very participatory development within the industrial life and democracy, right to understand may be a basic right which the citizen of free country aspire within the broader zones of the rights. Also, there are certain provisions like Article 32 and 226 of Indian Constitutions are relevant towards the consumer protection, because Supreme Court in many cases has diluted the concept of locus standi and allowed the general public, spirited individual or organization to enforce their rights and oppose the backward section of the society as an example. The Supreme Court has highlighted that in SP Gupta versus Union of India and opined that it must known to be thought to be well as a settled law where an individual would has suffered a legal wrong or wrong or whose right or legally protected interest is violated. There are also provisions under directive principles which deals with livelihood, obligation in cast upon the state to shield the consumer from exploiting and monopolist practices indulged in the large business houses. With this, I would like to sum up that consumers were measures the biggest economic clusters, invariable being remaining as a game changer for economic activities. It is because the king in ever-changing business state of the affairs. The discussion conjointly reveals that the consumer affairs theme has not been mentioned in union state list expressly. However, it is evident from preceding discussion that the state is remitted by the Indian Constitution, shield of customer against the restrictive trade practices, unfair trade practices, alternative consumptive practices against the customers. So lastly, I would like to highlight that there is a conjointly a requirement incorporate consumer affairs associate items within a list within a 7th schedule of the Indian Constitution, and Schedule 11 ought to be even fleetly amended to secure the actual involvement of Panchayat rule establishment within the implementation of the buyer welfare programs and activities. Thank you.
Thank you, madam. Our next paper presenter is Mr. Vijay Lakhera. His paper title is The Protection of Consumer in Insurance Sector. Mr. Vijay Lakhera. His paper title is The Protection of Consumer in Insurance Sector. Mr. Vijay.
Hello? Am I
Yes,
audible?
Vijay.
Anyone
Yes,
can
yes.
answer?
Yes, you are audible.
I am facing some difficulty in sharing my screen, so I start my as a orally. My present topic is. So I start my as a orally.
consumer protection in insurance sector. I am going, as we know that we have faced the peak time of the COVID-19 pandemic situation, that and we are still facing it. The person who has not interest in the insurance service, but nowadays are taking the insurance policy to protect himself from the unwanted situation. And we know that as a insurance companies who gives the insurance policy to the consumer comes under the provision of the Consumer Protection Act. That is there is a the contract between the consumer and the insurance companies. The insurance new Consumer Protection Act came with a new other effective provision beneficial to the all consumer and its right. Beside a law, the insurance law provides a significant right to the consumer insurance sector. The all over study have been done in the research paper right of the protection in the consumer sector. First, basically, we have to know that what are the rights of the consumer insurance sector are given. So that if the right of the consumer are infringed, that he may approach the district commission or respective commissions. My talk, I have referred to the literature that the Ravi Prakash Gupta and the study of the Dr. Agnes Kumar Agrawal. It is in this study they held that now the insurance company are more trustable, and they are reducing the insurance policies issues, holders issues. And in Bipin Kumar Gupta, they concluded the consumer protection concluded that only the consumer who are aware the provisions can exercise their right. First of all, we have to understand what are the rights of the consumer in insurance sector. The rights of the consumer protection are implemented from the effective provision of regulation in 2017. The regulation, that is the right of a consumer in insurance sector, covered under the Insurance Regulatory and Development Authority of India IRDA Protection and Policy Holder Interest Regulation 2017, in which the several rights are enshrined in this regulation. The first starting from the sale of the any insurance policy, the insurance company have to describe about the product description, is material information, scope and the benefit of the insurance policy, warranties, exclusion, exception or condition of the insurance policy. Thereafter, during the policy, he has to, the company, the insurance company has to tell the consumer all about the what the follow-up has to be taken by the consumer during the policy. That means the payment of the premium, withdrawal fees, benefit available of the main product, etc. And lastly, it comes from the company. It time to realize the amount of compensation amount at the claim procedure. The insurance company has to have to inform the consumer about the claim procedure, claim fee, time limitation of the claim procedure, what supported documents are required to be submitted with his claim, and a representation manner, and other norms and regulation of the claim scheme. Here, as we know that the insurance now the insurance has also established the insurance ombudsman, and ombudsman in the recent days we can see that from the data that the insurance ombudsman are disposing the very good rate, the cases with a very good rate, and consumer protection also it's help the consumer. So there are two remedies are available to the consumer. First of all, he may approach the insurance company by lodging his complaint at GRA, and if the complaint is not entertained by the insurance company, then he may approach the insurance ombudsman. Then apart from this internal machinery set up in the insurance law, the consumer may also approach, obviously, in consumer under the provision of the Consumer Protection Act, as per the pecuniary jurisdiction. In Supreme Court, the recent judgment of the Supreme Court is that there is a contract between the insurance holder and the insurance company. Apart from the contract, the beneficiary of the insurance policy, who are the third person, also cover under the Consumer Protection Act, and he can claim under the Consumer Protection Act. The second landmark judgment of the Supreme Court is that the insurance policy cannot change in the terms and policy during the insurance policy in the term of the insurance policy without informing or without agree upon the consumer. The insurance policy cannot go ahead with the contract terms of the contract. My conclusion that is that the insurance consumer protection is which comes with a new right and better machinery to resolve the complaint, and the effect of the new provision, the insurance company also seek that if they not resolve this complaint of the consumer, they may approach under the consumer protection. So the indirectly is impacted the service of the consumer insurance companies machine resolve machinery. And more secondly, my conclusion is that the more awareness is required to be widely publicity of the right of the consumer in insurance sector. So what are the right and what machinery set up in the resolve the grievances of the consumer. Thank you, all of you.
Thank you, Mr. Vijay. Our next paper presenter is Mr. Ajay Patel. His paper is Role of Central Consumer Protection Authority in Protection of Consumer Rights. Our next paper presenter is Mr. Ajay Patel. His paper is Role of Central Consumer Protection Authority in Protection of Consumer Rights.
એક જ મિનિટ મારું અનિતા મેમને મોકલેલી છે. Good evening all. My topic is the role of Central Consumer Protection Authority in protection of consumer rights. Now, first introduction, my title. The year of the 1986 is renewed as Magna Carta in consumer law because this was the year when the Consumer Protection Act 1986 was passed with intent to provide better protection of the interests of the consumer. But due to rapid growth of the globalization, liberalization and technology, the exploitation of the consumer has assumed in numerous forms. Additionally, the exploitation by e-commerce entity, consumer is sovereign and the customer is the king, are nothing more than in the present scenario practically in India. Since consumer protection is the social economic program, it is the primary responsibility of the government to protect consumer through appropriate policy measures, legal structure and administrative framework. Recently, the government of the India on August 9, 2019 received the presidential assent and published the much awaited Consumer Protection Act 2019 in official gazette. The major change brought under the act are the including the chapter the Central Consumer Protection Authority, which aim the regulate the violation of consumer rights, mediation to the provide specially disposal of consumer dispute, product liability, e-commerce, enhancement of jurisdiction of consumer force interest. My paper objective is objectives of research paper. This paper in face of the composition, selection, procedure, power, function and the mechanism of the Central Consumer Protection Authority to be establishment under Consumer Protection Act 2019 and its role of the effective implementation of the enforcement of these SEDEX. Methodology is a doctrinal research method, the study of mainly used secondary data, which are the law book, journals, monthly magazine article, online research like the ResearchGate, Google Scholar and various used by the relevant articles. Now, need for the Central Consumer Protection Authority. In Consumer Protection Act 1986, there was no authority establishment to look after the executive and regulatory actions specifically for violation of consumer rights, misleading the advertisement, unfair trade practice, etc. At in seen from the past experience of consumer dispute in that the complainant has to prove his claim by the adequating the evidence, especially in the case of the unfair trade practice and misleading the advertisement. It was the extremely difficult for the consumer to collect and produce the relevant document and evidence due to enhanced power of systematically between the parties. Therefore, the Consumer Commission was looked with the power of the inquiry and investigation due to which many consumer grievances were the remedies understanding. What is the Central Consumer Protection Authority? The authority is being the constitution under Section 10 of 1 of the Consumer Protection Act 2019. The Act replaced the Consumer Protection Act 1986 and seek to the wide its the scope in the addressing consumer concern. The CCPA is introduced in the new act aims to the protect the right of the consumer by the cracking down the unfair trade practice and false and misleading advertisement that are the determined to the interest of the public and consumers. The Consumer Protection Act 2019 has provided to the reinforced process of the administration and settlement of the consumer dispute with strict penalties including jail term for the manipulation and the misleading the advertisement through establishment of CCPA on base of the recommendation of the standing committee. The CCPA has filed within the gap of the investigation and inquiry recall of the goods and withdraw service that the hazardous on more significant change that has the root is that the consumer body of a class of consumer on their own the collect information of sharing complaint filed before the consumer commission. The headquarters of the CCPA will be situated in national capital in New Delhi and it shall be have the regional office in India. As the central government will decide to was a composition of CCPA, the proposed authority will be held by the Chief Commissioner and the central government in the exercise of the power of consumed by the Section 101 to F and G, read with the Section 10 2 and Section 11. Qualification for appointment of Chief Commissioner and the Commissioner in exercise with the power of central government appointment Mr. Nidhi Kahare as the Chief Commissioner of the CCPA. The qualification of Chief Commissioner and other commissioners shall be have the specially knowledge of and professional experience of not less than the 25 years of the economic, business, commerce, law, finance, accountancy, management, industry, public affair, administration, or any other matter which in the option of the central government may be useful of the central authority and shall hold effect for the term of the 5 year and eligible for the reappointment. The procedure of CCPA. The CCPA in exercise of the power conferred by the Section 104 to be and with Section 14.1 has effected CCPA election and transaction of business regulation 2019 invited for the views, comments, suggestion for the various stakeholders. It lays down the procedure of the transaction and business of CCPA. Now, power of CCPA. First, the power of the protect, promote, and enforce right of consumer as a class. The CCPA has the empower to the inquiry either suo moto or the distinction from the government to inquiry into the violation of rights and consumer as a class, unfair trade practice, misleading advertisement, which are the prejudice to public, and accordingly, the CCPA can be also bring an action and will be able to launch prosecution of behalf of the class of consumer of affected. Second, advisory and the regulatory power. The Act of 2019 has also empowered the CCPA recommends of appropriate remedial measures for effective implementation of protection of consumer rights under any other law for time being in the force and factor implement the enjoyment of consumer rights. Third, inquiry and investigation. The one more comprehensive power of the CCPA is the investigation and inquiry for the violation of consumer rights, unfair trade
We can
practice,
conclude,
false
Ajay Bhai. We can conclude.
Ma'am. Okay, ma'am. And lastly, conclusion and suggestion, the Consumer Protection Act 2019 has brought an additional shift and will be a grow from with more than power by let the consumer. The legislation has brought the meaning to the court of prevention is better than cure. Okay, thank you.
Thank you, sir. Our next paper presenter is Mr. Nikunj Rathod. His paper title is Consumer Protection and E-commerce Rules, Implementations and Challenges. Our next paper presenter is Mr. Nikunj Rathod. His paper title is Consumer Protection and E-commerce Rules,
Not
Implementations and
audible.
Challenges.
Nikunj bhai, Nikunj
Nikunj,
bhai,
sir.
Not audible.
Okay, sir. Fine, fine. Okay, am I audible? Sorry, sir.
Okay.
Nikunj bhai.
Fine. Good afternoon, all the dignitaries. My respected Dr. J.T. Desai, sir. My PhD supervisor guide, respected Dr. Jaydevi, ma'am. And respected Dr. Alkesh Swami, sir. Let me share my screen, sir. Okay, my PPT is visible to everyone now?
Yeah.
Okay, thank you. Fine. Title of my research paper is Consumer Protection E-Commerce Rules 2020 Implementation and Challenges. So this research paper is about to study proposed consumer protection e-commerce rules 2020, which are drafted but not notified, and what are the possible challenges for implementation. Fine. My objective of the study is to find out and analyze whether these rules are effective to cope up all the issues and problems arising out of the dealing with the e-commerce platform, to find out whether these rules can be implemented effectively, and to ascertain possible challenges in their implementations. So I will take my hypothesis statement is consumer protection e-commerce rules implemented in true spirit, they are framed and the scope of the adequately protect right of e-consumer. Let me give you some introduction. Recently in India, e-commerce rules 2020 were drafted for better protection of consumer, because in India, in urban areas, ratio of the consumer customers who purchase to e-commerce are higher than the offline market customers. And of course, there are so many traders that sell their goods and products online, which come under the purview of the rules. But the question is whether these rules can be implemented effectively. So, for this research purpose, I use mainly secondary data, which are law books, journals, monthly magazines, articles, online sources like ResearchGate, Google Scholar, that were used to gather the relevant articles. Let me give a very glimpse and very short highlight of the consumer protection rules, which are the actual main rules which are going to be notified very soon. That first one is these rules are applicable to goods and services bought over the electronic platform or digital network, all models of e-commerce. See, these rules are aimed at increasing liability for online e-commerce platform for goods purchased on the platform. Like e-commerce platform have to appoint a nodal officer, then no unethical, unfair business practice being conducted by the e-commerce platform, appointment of a grievance officer, connect with the National Consumer Helpline of the central government. They are taking the consent of the consumer in pre-tick checkbox form, restriction of manipulation of prices, ban on flash sales, display of all details like breakup of all the prices like delivery charges, return, terms and conditions, and to not conduct misleading advertisement. Now, what are the main issues that we discussed very elaborately? The first one is flash sale. See, in the e-commerce rules, they have stated that the e-commerce entity shall not conduct flash sale, but they allow conventional sale like big billion sales, which is conducted by Flipkart. Now they have given the reason. This is creating kind of confusion. On one hand, they are banning the flash sale, and on the other hand, they are justified conventional sale on the ground that it is conducted by the e-commerce entity every year. But if we look deeply, the matter is not all about the certainty of a time of sale, but the products and services are being sold on that day with a very low price that will damage the offline market. That is one issue. The second one is preferential treatment search practice. Now, what is that? See, most of the e-commerce entity have set their algorithms and they are doing unethical algorithm practice. What is that? They set their algorithm to preferential search, or we can say manipulating searches. If you are searching something you want to from that digital platform and you type something specifically, but even after they show product other than you want. Suppose before 2-3 days back, I want a TV. I want to buy a TV. I open up Amazon and I search Samsung television LED and they show me not Samsung but Amazon Basics. Amazon Basics is nothing but the own brand of Amazon. I have never typed Amazon A. I have clearly typed Samsung LED TV. But rather than they show me the Samsung product, they are showing me the Amazon Basics, which is their own product. Now, this is nothing but the unethically algorithm practice. Using this kind of practice, they push their desired product. Using this kind of malified practice, they push their desired products irrespective of your choice. Indirectly, they are diverting the customer's mind to other products, which is unethically and which is not covered by the e-commerce rules. The third one is terms and condition. Now we know all of the if we go through the all of the e-commerce rules, they have clearly mentioned that the e-commerce entity must have shown all the details of the products like breakup price, return, but very technically and very smartly they write terms and conditions very in small font. See, but e-commerce entity are trying their best and take care of that thing that customers should not read this part. They are given in very small font which is not readable or even visible, and they make all possible effort for customer to avoid this part. Rather they showing discount amount big fonts, so customers just see that and go for the purchase. So there are no such specific guidelines for a content display. They have shown that your display for the product, each and every product is display with the breakup price, with the return, but terms and condition is very small kind of font which is not easily visible by the customer, which is unethical practice. The fourth one is attitude of e-commerce companies, specifically with Indian customers. Now what is happening? Most of the e-commerce entity, of course, Flipkart is an Indian company, most of the people, but they don't know. Flipkart is registered in Singapore and now Flipkart is owned by Walmart. So Amazon and Flipkart, there is a, forget about Flipkart, but let me take example of Amazon. Amazon is an e-commerce company, American based. But one thing is noticed that they have a different kind of dilemma and different kind of behavior with the American customer, while they have a different kind of ideology or a relationship with the Indian customer is very bad actually. But what we notice that there is a behavior and attitudes towards the Indian market and Indian customer is not the same like the other country customers. Most of the foreign companies are biased with the Indian customer. That is a bad thing. And for the attitudes of the e-commerce company, there is no such specific rules that is given in the e-commerce rules. Then pre-tick checkbox. When the e-commerce Consumer Protection Act 2019 came into force, and the rules were coming into 2020, but not yet notified. Pre-tick checkbox. Most of the e-commerce entity are taking concern by a way of pre-tick checkbox, which is ethically wrong. But most of the company, even today, they are doing this practice. That e-commerce platform are taking concern by way of pre-tick checkbox only, which is wrong actually. But there is no such provisions in Consumer Protection Act as well as in e-commerce rules. Then we're talking about the class action. So this is the kind of a very useful tool which is widely used in America.
Nikun sir,
it's a kind
can
of
we
representative.
Nikun sir,
Yes,
can
yes, ma'am. Yes, ma'am. Yes, ma'am. Yes, ma'am. And see, misleading advertisement and the fake review. Now, this is important one. There are no specific rules for or provision for the fake review. Fake review is also part of false or misleading advertisement. But most of the e-commerce companies are conducting this practice. So, if we conclude with the suggestions, consumer awareness program must be conducted by the government as a time to time or regular time, because most of the e-commerce consumer are not aware of their rights. It is not the duty of the government to draft the rules, of course, but it is the duty of the e-commerce to aware their customers also and to tell them that we are also bound to follow these rules. Of course, the vision of the government is good, but it will take some time to implement. With this, I conclude my presentation. Thank you so much for giving me this opportunity. Thank you so much.
JT sir, Jaidevi Ben, Alkesh Bhai, would you like to sum up?
Thank you for giving me this opportunity.
Yes, it's a nice experience. There was a problem of scarcity of time. However, all participants had given their presentation very nice, and we are very happy. Once again, we'll meet day after tomorrow. Thank you.
Thank you for your valuable time. Anisha ma'am, please take over.
Thank you, sir. Thank you, Dr. J.T. Desai, sir, Dr. Alkesh Swami, sir, and Dr. Jaydevi Rajaguru, madam. for making time for this conference and for being session chair for the second session of the national conference, and the participants for making this technical session valuable and insightful for all our attendees. I would now request Dr. Irmala Dayal Madam to end the session with her closing remarks. Over to you, ma'am.
Thanks, session chairs. There was a bit of delay. I regret it. Monday will be tried to be on time. Meaningful deliberations have taken place today. And this conference would not have been such a huge success without your active participation. Thanks, JT sir. You're always very supportive. Alkesh Bhai, as well as Reddy, and all my dear participants. Thank you.
Thank you, ma'am.
Thank you, ma'am.
Thank you, madam.
We end this meeting and we join the Zoom meeting, madam.
Yes,
Alkesh
sure,
Bhai,
ma'am.
તમે કઈ કહેશો? Will you say something, Alkesh Bhai?
નહીં મેડમ, બસ ખૂબ સરસ કાર્યક્રમ છે. બધા જ પાર્ટિસિપન્ટ ખૂબ સરસ પાર્ટિસિપેટ કરી અનફેર પ્રેક્ટિસ અને ઈ કોમર્સ વિશે ખૂબ સરસ માહિતી આપી હતી. અનફેર પ્રેક્ટિસ તો મને પણ કરવાની ઈચ્છા થઈ ગઈ હતી, કેમ કે મારી સાથે ચેરપર્સન તરીકે તમે જેટી દેસાઈ સાહેબને મૂકેલા હતા, જે મેં આદર્શ શિક્ષક તરીકે મેં એમને જોયું. કદાચ એમને આદર્શ બનાવી હું ચેરપર્સન તરીકે એમની સાથે જો સ્ટેજ શેર કરી હોત, હું મારી અનફેર પ્રેક્ટિસ કરી શકતો. પણ સરસ, ખૂબ સરસ કાર્યક્રમ હતો. બધા જ પાર્ટિસિપન્ટ સારું પ્રેઝન્ટ કર્યું હતું. મેં પણ માર્કિંગ પણ કરી રાખેલું છે, એ સીટ આપણને મોકલી. સરસ, ખૂબ સરસ કાર્યક્રમ હતો. બધા જ પાર્ટિસિપન્ટ.
Thank you so much, all of you.
થેન્ક
We end this meeting અને અનિશા બેન આપણે Zoom meeting join કરીએ, Google ની બીજી meeting join કરીએ.
Yes, ma'am. With this, we come to an end of the day one of the second virtual two-day national conference on expanding horizons of consumer rights. It has truly been an enriching experience and we hope to see you all tomorrow. Thank you.
On Monday, we don't work on Sundays.
Yeah, ma'am. On Monday, 28th February 2022.